don't share in Your Honor's faith in making that assumption.
Well, just have Detective Harper here. All right. As to this case, we're in recess until 8:30 a.m. Monday. All right, we'll reconvene court at 1:30 on the sentencing matter.
Then you placed it on this table, is that correct?
That's correct.
All right. And then it was filmed then by Mr. Ford, is that correct, sir?
That's correct. It was also photographed by still photography also.
Now, as I understand your testimony also, the video was shot after the recovery of all the evidence in the residence, is that correct?
That's correct, yes, sir.
Now, did you make any notes, or do you have any police reports at all with reference to your receipt of the tape and placing it in your drawer and then later in the file cabinet?
No, sir.
Have you made any notes or any reports about your subsequent turning over of this tape to the district attorney's office?
No, sir.
And so that we're clear, what date was that you turned it over to the DA's office?
That was, I believe it was turned over to them on March 24th.
It was a Friday.
Yes, sir.
Very well, thank you very kindly.
Ms. Lewis?
Good morning, Detective Looper.
Good morning.
The glove that you recovered from the top drawer of that one of those chest of drawers in the defendant's, was that in the defendant's master bedroom walk-in closet?
That's correct, yes, ma'am.
And was that glove alone, or did it have a mate when you recovered it?
It was a lone glove located in the left corner of the drawer.
And is the fact that it was a lone glove what caused you to have some concern that it might match the other glove recovered on the property?
Certainly was a consideration, yes, ma'am.
Did you determine that that glove that, well, first the one that you recovered was a right-handed glove?
Yes, ma'am.
And you were aware that the glove recovered along the south pathway was also a right-handed glove? Or
No, I'm sorry.
I'm sorry, I misspoke. You became aware of that after speaking to Detective Lang or Van Adder later on?
That's correct, yes, ma'am.
Now, your duty at Rockingham was to direct the execution of the search warrant, which Detective Van Adder had obtained, is that correct?
That's correct, yes, ma'am.
And you were left in charge of the scene for that purpose because Detectives Van Adder and Lang, the most senior lead detectives on the case, went downtown for the purpose of speaking with Mr. Simpson, is that right?
Well, I knew that Detective Van Adder had responded. I was unaware that Detective Lang had also responded to Robbery Homicide Division.
Do you recall at this time what time the SID photographer arrived on the premises?
Which SID photographer?
Did you cause an SID photographer to come to take crime scene photos for your use in investigating that location as a crime scene?
There was one already at the location when I arrived.
And do you know what time he or she had arrived?
Without looking at the crime scene log, I couldn't be accurate, but it was in the morning sometime.
Would that refresh your recollection to take a look at the Rockingham crime scene log?
Yes, ma'am, it will.
Your Honor, I have an unmarked up copy of that, which I'll show you now. May this be marked, I'm not sure what exhibit number for purposes of
For
this
the
hearing?
purposes of this motion, I guess the videotape is,
1068 defense.
let's make this people's next in order.
I'm not clear about what she can do at this time.
This is to refresh the recollection of the witness, is my understanding.
Yes.
As to the timing of when certain personnel arrived at the scene.
Well, Your Honor, the problem is that he wasn't there. I'm not clear of his document, just reading that document for the first recollection.
But he was there, was my understanding.
Well, it depends on what time, which witness. Well, let's see.
And people's next in order would be,
158.
I'm sorry, 1058?
158. People's 158. Excuse me.
Detective Looper, what time did you personally arrive at that Rockingham location?
Arrived about 12:10, 12:15 in the afternoon on the 13th.
And you indicated that the SID photographer had indeed arrived prior to your arrival?
That's correct, yes, ma'am.
Now, were you in the presence of the SID photographer when that photographer was taking photos at the scene?
On the exterior shots, no. On the interior shots, yes.
Did you attempt to direct the photographer on those interior shots of what to photograph?
That's correct, yes, ma'am.
And your purpose in doing so was to preserve for investigative purposes the crime scene, the Rockingham crime scene, is that correct?
That's correct, yes, ma'am.
Do you recall approximately what time you first noticed the SID photographer taking photographs of the crime scene?
1:45. We're talking about the inside of the residence. It was about approximately 1:45.
Even the exterior, do you recall about what time that might have been?
That would have been 12:20 to 12:30, I suppose, somewhere in that neighborhood.
When the SID photographer was taking photos, had all of the evidence which you eventually recovered been taken into possession yet, or was much of it still there, recognizing there were not a lot of things besides blood recovered on the 13th?
The purpose of the initial photographs was to record it as we found it. And later on, as the evidence was collected, it was also photographed.
Do we have Defense 1068, the videotape? Do you all have it? To play just the beginning of Defense 1068 for purposes of showing timing of the arrival of the videographer. I tell you what, could you
Tape.
stop it and rewind it? While he's doing that, Detective Looper, after completing the photographs of the crime scene and recovering evidence, did you make an attempt to do something with regard to the premises in terms of the way you had first found them?
I returned it to as close as the way I had found it, maybe a little better.
And that was prior to the videotape being taken?
That's correct, and the purpose of that was to ensure that both Detective Lang and Van Adder got a proper feel for the rooms in the residence as I had found them.
So the way that something appears on the videotape may not reflect the way it appeared at some point between the crime scene photos and a point thereafter when the evidence was actually collected. Is that correct?
That's correct, yes, ma'am.
So one could not tell, or you could not tell from looking just at the crime scene videotape in relation to the crime scene photos, you could not necessarily tell when evidence was collected. Is that accurate?
That would be accurate, yes, ma'am.
Now, what is your best recollection as far as when the items of real evidence were collected from the interior of the location, in terms of the timing, whether it was prior or after the shooting of the videotape?
It was prior to the shooting of the videotape, anywhere from 2:30 to 4:15, I would say.
And was it your belief that the socks had been recovered from the carpet in the master bedroom prior to the videotape being shot?
Yes, ma'am.
And did you, you've watched the videotape, have you not?
Yes, ma'am.
And did you notice that the tape happens to stop before showing the location where the socks had been recovered from?
Yes, ma'am.
So it's also possible the socks were still there when the videotape was shot.
Sustained. Sustained.
So you can't tell from looking at the videotape alone exactly when the socks were recovered, is that fair?
Sustained. I have seen the tape now 5 times, so, and here in court 2 additional times.
Were you present with the videographer when he was videotaping the master bedroom?
No, ma'am.
Is the tape back up? You just played it during first couple of minutes. All right, you notice, Detective Looper, as the tape is flowing, that shows 211 on the, apparently on the equipment itself.
Yes, ma'am.
And is that the arrival of Mr. Atkins, who testified earlier at the scene? Does it appear to be that?
It would appear to be that, yes, ma'am.
And that's Detective Jim Harper, who was shown just with greeting him?
Yes, ma'am.
All right, you can stop it now, please. And the is your arrival time shown on the crime scene log of Rockingham, People's 158 for identification?
Yes, ma'am.
And do you have an independent recollection of exactly when the videographer arrived at the crime scene?
Not an independent recollection without looking at the crime scene, ma'am. Crime scene log.
Would it indeed help refresh your recollection to take a look at that crime scene log?
Certainly would.
May I approach?
Yes.
Showing you People's 158 for identification, the crime scene log, would you take a look at that and see if that refreshes your recollection as to the arrival of Mr. Atkins and Mr. Ford?
It would appear that it would, yes, ma'am.
And what time did they arrive?
10 minutes after 3 in the afternoon.
And do you have an independent recollection of exactly when they left as well?
Not an independent recollection because I didn't see them leave, but according to the crime scene log, it shows...
Ask the question.
Sustained.
When is your best recollection of the last time you personally saw Mr. Atkins and Mr. Ford at the crime scene, at the Rockingham location?
Probably 3:45 in the afternoon.
During the time that the video was being shot, was either Detective Lang or Detective Phillips there?
No.
Do you recall what time, do you have an independent recollection of what time Detective Lang and or Detective Phillips arrived at the, Detective Van Adder arrived at the Rockingham location?
They arrived approximately 10 minutes after 5, 20 minutes after 5, right in that neighborhood.
Now, how did it come about that this particular videotape was shot? You were in charge of the search warrant execution there at the crime scene. Did someone give you that idea at some point in time?
Detective Harper approached me after his arrival and suggested that we videotape the valuables in the residence, and I agreed.
And what was your purpose in doing that?
The purpose of it was strictly for civil litigation. We knew that Mr. Simpson had quite a few valuable and personal articles that he had won throughout the years, and we certainly didn't want to be accused at a later date for either breaking them up or stealing them or whatever.
So were you the person who actually made the decision to have that done, to have the scene videotape?
Yes, ma'am.
And did you direct Detective Harper, Harrow, or someone else to call SID and have someone come out for that purpose?
That's correct, yes, ma'am.
In fact, in terms of your concern that the crime scene not sustain damage when the search warrant was executed, did you ensure that something was done with regard to the vanity in the master bedroom and fingerprint dust?
Yes, ma'am. The vanity, well, not the vanity, you're talking about the linen closet, I believe.
Was there a location where newspapers were placed to ensure that the dust did not hurt the carpeting?
Yes, ma'am. It was a linen closet or a cabinet at the top of the stairs that prior to being fingerprinted, I requested that newspaper be put on the ground so as not to damage the carpet.
You've reviewed all of the crime scene photographs from Rockingham,
Yes, ma'am, I have.
and of course you've also seen the videotape, as you told us. Is that right?
Yes, ma'am.
Is there anything shown on the videotape, any area, as best you can recall, that's not also shown on the photographs themselves?
Yes, ma'am.
And what area is that?
That would have been the linen closet area at the top of the stairs.
The one you just described?
Yes, ma'am.
And did that linen closet turn out to have any particular evidentiary significance?
Had no evidentiary significance at the time, no, ma'am.
Nothing was recovered from that closet?
No prints were recovered, no scientific evidence was recovered, nothing.
After the videotape was completed, was there a time when you personally obtained possession of it again? Or I should say for the first time, when you personally got the tape?
I got it on the 14th in the morning.
June?
Yes, ma'am, June '94.
Do you recall from whom you received it?
I received it from Detective Harrell.
And where were you at that time?
I was in my office at Parker Center.
And what did you do with the tape?
Went upstairs to the electronics section, viewed it, and returned down to the office to prepare my employee report regarding the search, and I was informed that it wasn't necessary based on the fact that the captain had been at the scene.
Was it necessary to do an employee report of the existence of the videotape?
No, an employee report regarding the execution of the warrant and how the premises were before we arrived, as well as how they were left.
You indicated the captain, is that Captain Gartland?
That's correct, yes, ma'am.
You indicated he had been at the scene?
Yes, ma'am.
A couple of minutes ago, you informed defense counsel that there were 5 detectives at the scene, to the best of your recollection. Do you recall when Captain Gartland was there?
He was there after I left, and I believe counsel was making reference to who was present during the taping of the residence.
Now, where did you place the videotape after taking possession of it on the 14th?
I put it in my desk drawer.
And did there come a point in time when you moved it to the room at RHD, which was set aside for the Simpson case?
Yes, ma'am.
Where inside that room did you place it?
It was placed in a filing cabinet, a locking file cabinet, along with several notebooks that I had in my possession.
Have you been primarily involved, since that time of the execution of that search warrant, primarily involved with a certain aspect of the investigation of clues and other items related to this case?
Yes, ma'am, I am.
And what area of the investigation has been the focus of your involvement?
Chicago.
And have you made several or numerous trips to Chicago over the course of the last several months?
It's vague.
Roughly how many times have you been to Chicago as part of the investigation in this case?
I've been there 4 times.
And in addition to the Simpson case, have you had other murder cases which you've been responsible for investigating and solving?
Yes, ma'am, I have 4 others.
And in terms of when the murders occurred, how many of those did the murders occur prior to the murders here on June 12th?
All but 1.
So 3 of the 4 were murder cases which came into existence after the murders in this case, is that
No.
right?
The other way around.
Okay, so 3 of the murders occurred, and then 1 came into existence, or 1 murder occurred, I should say, after the murders in this case.
That's right, yes, ma'am.
And have any of those 4 cases been completed in terms of through conviction or acquittal or some final disposition?
Sustained.
Your Honor, it
Sustained.
just goes to show that he was...
Sustained.
So you have, is it fair to say that you've been working very hard not only on the Simpson case but on other murder cases as well?
Yes, ma'am.
Did there come a point in time when you recalled the existence of the administrative civil liability videotape?
Overruled. I'll decide what it is.
Yes, ma'am.
And I think you told us Friday, under Mr. Cochran's questioning, that Detective Van Adder alerted you that you would be testifying with regard to the search in this case. Is that right?
Yes, ma'am.
And subsequent to that, you started to think of crime scene photos and anything else that might be around in that regard. Is that correct?
That's correct. Yes, ma'am.
And was your purpose in doing that thinking of aids that would be helpful in refreshing your recollection of the events that transpired during the execution of the search warrant on the 13th?
Yes, ma'am.
And is that approximately at some point after that, is that when you thought of this videotape as well?
That's correct.
Now, when you thought of it, when did you, or what did you do in terms of going looking for the videotape?
Well, the first place I went to is the SID electronics lab, figuring that it had been booked. However, I found that it had not been booked. Then I remembered that I'd seen it in the filing cabinet along with several other notebooks early on in the year. So I went up there, and there it was.
So it was in the identical location where you had left it on June 4th, well, at some point when it was moved, when you moved it into the war room?
Yes, ma'am.
The war room meaning the room set aside at RHD for the Simpson case?
Yes, ma'am.
So it appeared that no one else had moved it, or it did not appear to have been moved at all within that file cabinet. Is that accurate?
That would be accurate. Yes, ma'am.
How was this tape marked?
It was marked with the standard label, just O.J. Simpson's house.
You indicated Friday that someone notified the city attorney's office of the existence of the tape.
Yes, ma'am.
Did you do that yourself, or did someone else?
That wasn't done by me, no, ma'am.
Are you aware of what the purpose was in doing so?
Not really.
Overruled. He said not really.
Is the, I'm sure the court knows this, but for the record, is the city attorney's office, do the city attorneys represent the department when it's sued for things such as destruction of property during search warrants?
That's right, yes, ma'am.
They're the department's lawyers, so to speak?
Yes,
Not just
ma'am.
so to speak, but they are.
Yes, ma'am.
May I have just a moment, Your Honor?
Certainly.
Detective Looper, why didn't you have the videographer record the glove along the south side of Rockingham?
Well, the purpose of the tape was not to record where evidence was located. It wasn't a crime scene per se tape. Had it been, we would have been recording the inside of the Bronco and other areas, and just that wasn't the purpose of it.
And
The evidence is in fact not evidence. The court is well aware that very clever had been moved earlier, and that understands that question is not simple.
Overruled.
And what were the blood drops on the driveway videotaped?
No, ma'am.
Now, did you notice that apparently a couple of blood drops on the foyer of the interior of the house were videotaped?
That's correct. Yes, ma'am. I saw that.
And did you notice that the wood where those drops appear also appears to be light-colored wood?
That's correct. Yes, ma'am.
So those blood drops would represent, in addition to perhaps crime scene purposes, damage to the property, whether caused by LAPD or someone else, but they would represent some minor amount of damage. Is that correct?
That's correct. Yes, ma'am.
Thank you. I have no further questions.
with regard to the glove allegedly found on the south side of the property, by the time you arrived at the location in the afternoon of June 13th, that glove had long since been removed. Isn't that correct, sir?
That's correct, yes, sir.
So it'd be nothing to photograph. Isn't that correct, sir?
That's correct, sir.
Now, by the way, while you were out there on June 13th in the afternoon, Detective Looper, did you see Marcia Clark from the DA's office out there?
She was there, yes, sir.
So she was actually there. At what time was she there?
She had to have been there somewhere in the neighborhood of, excuse me, between 2:20 and 3 o'clock, somewhere in that neighborhood.
And how long did she stay, if you recall?
She was there long enough to get a walk-through, and then she left. I don't know, she was there probably 5, 10, maybe 15 minutes, I don't know.
Did you see her at some time while she was there sitting at a table talking to Detective Furman?
Oh, well. No, sir, I did not.
You did not see her being briefed by Detective Furman at all?
No, sir,
Who gave her this walkthrough?
I did.
And what time did the walkthrough start, if you recall?
Overruled. It's
just-
probably the most relevant question I've heard so far this morning.
Thank you, Your Honor. Okay.
This
She's not
this
used
is
to
a
the rules, Your Honor.
discovery sanctions issue, I
Right.
think.
Counsel's not used to the rules either, Your Honor. We don't argue back and forth. Thank
No,
you.
we're in an informal setting at this
Oh,
point.
we can do it now? Oh, good, Judge. Thank you. I'll remember.
No, we can't, but
Okay.
I'll let it slide
All right.
at the
Thanks,
moment.
Judge. All right.
But
I'm
we've
sorry.
wasted a lot of time. All I'm interested in is what happened to the tape? Why did it disappear? When did it come to light? How did it come to light? Who knew it existed and when?
All right. Okay. See if we can answer those questions real
All right.
quickly. Detective Looper, other than you, let's start with who knew about the existence of this tape? We know that you knew about it, right?
That's correct.
Mr. Ford knew about it.
Yes, sir.
Mr. Atkins knew about it.
Yes.
Captain Garland knew about it.
I don't believe Captain Gartland knew about it.
Well, did you talk to him about having to fill out this report or not having to fill
No,
out this
I
report?
was informed that he had been at the scene, and knowing the procedure within the department, if the captain is there, that negates the 15-7 or the employee report.
All right. Now, in addition to that, the 5 detectives that we talked about who were at the scene knew about this tape, Harrow, Harper, et cetera, right?
calls for speculation.
Overruled.
Now, they saw the tape being shot, didn't they?
I know that Detective Harrow and Harper were aware of the tape. I was aware of the tape. I don't believe my partner was aware of it, and I don't know if Detective Roberts from West LA was aware of it or not.
In addition to that, there were some patrol officers also at the location, isn't that correct?
That's correct, yes, sir.
And so that we're clear, part of this tape was shot outside, so people outside could see that it was being shot, isn't that correct?
That's correct.
Overruled.
And anybody who was outside close enough could see that video was being shot outside, isn't that right, sir?
You would assume that, yes, sir.
All right. And then you cannot tell us about LaFall, your partner, whether he knew or not.
That's correct.
Did you talk to him about it at all?
No, sir.
Okay. And you can't tell us whether or not Roberts knew or not. Is that correct?
That's correct, yes, sir.
Now back to Ms. Clark. Ms. Clark was there, and you took her on a walkthrough after the search warrant had been completed?
After the evidence had been located, yes, sir.
Right. So the search warrant had been executed at this point. And you took her, tell the court briefly where you took her. You went through this walkthrough.
I took her through the bottom location of the residence of the first floor to show where some of the presumptive tests I wanted done. Took her upstairs, showed her the the linen closet, and showed her the socks and the blood evidence that had been found in the bathroom. And took her, I think, to the side of the house, showed her a wire that I wanted checked, and what was in the trash can there by the entryway to the office. I believe it was an airline ticket. And then on the exterior, there was a bench seat right there by the front door that had a luggage tag thrown on one end of it. and that was also pointed out to her.
Did you make a report of all of your observations with Ms. Clark?
No, sir.
You know, have you seen any report with reference to your taking her through the premises and noting these objects?
No, sir.
You never made a report like that, did you?
No, sir.
Did Marcia Clark sign in on the log when she came to that residence?
You won't find her on that log, no, sir.
Why won't we?
Good question, I don't know.
Well, was there any other log that she signed in on when she came there?
To the Rockingham location?
Yes, the Rockingham.
No, sir, not that I'm aware of.
So you have no reports which tell you exactly what time she got there. So you have to give us only your independent recollection, is that correct?
That's
Without
correct, yes,
reports.
sir.
So you're not sure of the exact time she got there and the exact time she left, are you?
I'm as sure as within 45 minutes of when she did arrive and when she might have left, based on the sign-out log of Bundy.
But why is Bundy relevant? She went to Bundy after she was at Rockingham?
She went to Bundy first and then came out to our location, is my understanding.
Had you seen her at Bundy?
No, sir.
All right. But you know, through subsequent information, you found out she'd been to Bundy, then she came to Rockingham.
Oh, well,
If
That's
you know.
correct, yes,
All
sir.
right. And basically, you cannot tell us exactly what time she got there or what time she left, can you?
I can just give you an approximation, sir.
All right. And what's your approximation again?
Somewhere between 14:20 or 2:20 in the afternoon to 3 o'clock.
That she arrived?
Right.
Right.
That's how much time she'd spent. That's approximate time.
All right. Is that the approximate time that she arrived or the time she spent?
The entire time, when she arrived, spent, and left, is just an approximation on my part.
Was Ms. Clark accompanied by anyone else when she arrived there, sir?
No, sir.
She's by herself?
That's correct, yes, sir.
You didn't see any other deputy DAs there that time?
No, sir.
Did you see her talking with any other detectives other than yourself while she was there, Detective Looper?
No.
Now, you stayed until about 6:35 in the afternoon or evening, right?
That's correct, yes, sir.
Per the log. And you were still there when Lang and Van Adder came, isn't that correct?
Yes, sir.
And they came sometime after about 5:15 or 5:20, right?
That's correct, yes, sir.
Now, with regard to the shooting of this tape, it's true, is it not, that with regard to videotape, one of the best ways of preserving evidence for later presentation to a jury in a case would be a videotape of the crime scenes. Isn't that correct?
Well, I think that's a matter of opinion.
Well, I'm just asking you. Would, as a detective, what do
No,
you think?
I disagree with that.
You don't think that an actual videotape of what went on would be more accurate than, say, still photographs?
I think still photographs are a lot more effective than video.
Congressman, this area of
All right.
inquiry, although interesting, is
All right,
not
Your Honor.
relevant to the
Then
issue.
I'll move right on then, Your Honor.
All right.
It is interesting, though.
It is.
I think, right, but so stipulated. In this instance, however, you shot this video primarily for purposes of civil liability, is that correct?
Yes, sir.
Was there a city attorney at the scene?
No, sir.
Would you agree with Mr. Atkins if he indicated, however, the videotape also served the purpose of helping detectives in the course of their investigation if they wanted to come back and serve another search warrant as to the location of certain items?
Well, I've never had an occasion to use it, so I really wouldn't want to even speculate.
You wouldn't speculate on that?
No, sir.
So that we're clear, you took Ms. Clark on a tour of the outside of the premises and the inside, is that correct?
That's correct, yes, sir.
When Lang and Van Adder arrived at the premises, did you have occasion to talk with them?
Yes, sir.
And you and Detectives Lang and Van Adder all work out of robbery homicide, is that correct?
That's correct, yes, sir.
Thank you, Your Honor.
Briefly, Your Honor. Detective Looper, actually, at that point in time, your only purpose in having that videotape taken was for civil liability reasons. Isn't that true?
Yes, ma'am.
And your best recollection is that Marcia Clark left the premises at about 3 o'clock or by 3 o'clock within that time frame.
That in that approximate time frame, yes, ma'am.
And the videographer arrived at approximately, as we know from seeing the videotape, approximately 3:11 or so. Isn't that true?
That's correct, yes, ma'am.
Thank you. Thank you.
All right, Detective Looper, thank you very much, sir. Cochran.
I have one last question, before you.
Sure.
Do you recall whether or not Mr. Atkins and Mr. Ford had arrived prior to the time that Ms. Clark arrived?
No, they arrived after Ms. Clark had been there and gone, sir.
You sure about that?
Yes, sir.
Does your log, of course, there's no log that reflects that, is there?
Well, Judgment Day.
I'm asking.
Overruled.
Is there any log that reflects that?
As I indicated earlier, I don't have her checked in or checked out at the Rockingham location, and I'm giving you the best recollection that I can.
Just one more question. Your Honor. So if you have them in at 3:10 in the afternoon, it's possible Ms. Clark may have been there as late as 3:10, isn't it?
Well, objection calls for speculation.
Well, I'm asking.
Overruled.
It's possible, isn't it?
No, because she wasn't there. She and I stuck together, excuse me, stuck together, poor use of the word. We were together through that time while she was there, and I did see her leave before they arrived on the scene, sir.
All right, so you're sure about that, right?
Yes, sir.
All right, so when you told us that she came perhaps at 2:10, stayed till perhaps 3 o'clock or so, those were just estimates, weren't they?
That-
Misstated estimates at 2:20.
2:20 to 3:10.
That's my recollection, yes, sir.
All right. But if you were to, you saw this log, and the log indicates they arrived by 3:10, isn't that correct?
That's,
Objection Vegas removed.
Atkins and Ford.
that's correct, yes, sir.
Thank you. Your Honor.
Nothing further.
All right, Detective Looper, thank you very much. Your excuse, sir.
You're welcome, sir.
Mr. Cochran, any of the witnesses on this issue? All right. All right, Detective Harper.
You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Please have a seat in the witness stand and state and spell your first and last name for the record.
James Arthur Harper, H-A-R-P-E-R.
Good morning, Detective Harper. How are you this morning? Sir, I'd like to direct your attention back to the date of June 13th, 1994. In the afternoon hours, you were assigned as a detective from robbery homicide and were at the Rockingham location, were you?
That's correct.
And to the best of your recollection, what time did you arrive at that location on that date?
At 10 minutes to 2 in the afternoon.
And did you arrive in the company of some other officers?
Yes.
Who'd you come with?
My partner, Detective Richard Harrow, and Detective Cliff LaFall.
All right, any other officers?
We came in the same car, so I don't believe that there was anyone else.
So the three of you came together,
Yes,
Harrow, yourself, and LaFall.
yes.
All right. And when you arrived at the location, did you have occasion to see some other officers there, some other detectives from robbery homicide?
Yes.
Who did you see there?
Detective Furman, Roberts, and Detective Phillips, Detective Looper, and it was quite a few other people there too. That I don't recall any other names.
All right, so would I be correct in assuming there were at least 7 detectives there after you arrived with your 3?
At least 7, yes.
So there'd be at least you, the 3 of you, Looper, Furman, Phillips, Roberts, were all there at that point, is that correct?
Yes, sir.
Now, at some time after you arrived, were you aware of the arrival of a Mr. Atkins and Mr. Ford from the photographic lab of the Scientific Investigation Division?
Yes.
In the best of your recollection, what time did they arrive?
I believe they got there about 10 minutes after 3,
About 3:10?
about 3:10, yeah.
And when they arrived, did you have occasion to speak with Mr. Ford, an actual photographer yourself?
Yes, I did.
And did you give him some instructions, sir?
Yes, I did.
And would you tell the court what you told Mr. Ford upon his arrival at about 3:10 in the afternoon on June 13th?
I met Mr. Ford and Mr. Atkins out front at the Rockingham gate, and I told them that we needed them to photograph first the outside of the estate and also inside, and it was for administrative purposes. And that's basically what I told them. We started outside. I directed them to shoot the outside and the sides of both the north and the south side of the house.
All right, you specifically told Ford to shoot the south side of the house?
Yes, the garage area.
And did you see him shoot the south side of the house?
Yes, I was standing right next to him.
And that, as far as you know, that's on the video, the shooting of the south side of the Simpson residence?
I believe so.
And with regard to this administrative purposes that you spoke about, the police didn't do any damage to the outside of the house, did they?
No.
As you just had the outside of the house shot, though, is that correct?
Yes.
North and south sides?
Yes.
Do you know whether or not there's a walkway down the south side of the house? Was there any shots made of that particular part of the house? The walkway on the south side?
I believe it was done from a distance, from the street,
Okay.
as he was walking toward. He was shooting as he was walking toward the house.
Okay, and that was done by Ford.
Yes.
All right. And then, how long, if you know, did he spend shooting the exterior of the Rockingham residence?
Probably, he was there a total of probably maybe an hour and 10 minutes, but I think it was only like 25 minutes of actual film from when I remember watching it. It was only like 25 minutes long.
Is that 25 minutes of outside and interior? Or
Yes, the whole shot.
the whole thing? All right, now, while Mr. Ford was there and shooting, Marcia Clark came, did she not?
I believe I remember seeing her there at some point.
And you recall that while she was there, was Ford shooting the video during that period of time? Do you recall?
I don't recall if he was or not.
All right, and tell us what time is your best recollection that Marcia Clark arrived on the scene?
We got there at, like I said, we got there at 10 minutes to 2. We left at 4:30, I believe. So she got there sometime between that time. I don't recall. I just remember seeing her briefly.
Between 1:50 and 4:30.
Yes.
And have you had occasion to review any logs or anything that might refresh your recollection as to what time she actually arrived?
No, I have not.
If she doesn't appear on the log, is that an indication that she just didn't sign in when she got there?
That's a possibility.
Do you recall, once she got there, tell the court what you observed her doing, if anything?
I believe at one point I saw her talking to Detective Furman.
She was seated at a table, wasn't she, sitting down outside talking to Detective Furman?
At one point, yes.
And how long had she been there at the time that she was seated at this table talking to Detective Furman?
I don't recall because I don't remember seeing her come in.
So you don't know when she'd gotten there, you just saw
No.
her talking to him?
Yes.
How long did you see them talking, if you know?
They started outside, and then I believe they came inside because of the helicopters and the news people were above.
Taking pictures of them, right?
I assume, yes.
So
And they
start-
came,
Sorry.
and they came inside and started talking. So total of probably, that I saw, the conversation had not stopped. So I don't know how long she talked to him.
Well, just tell the court then, how much time did you see him talking? Even keeping in mind you didn't see him when they started, and keeping in mind you didn't see him when they finished. How long did you see them talking?
Maybe 5 minutes.
And part of that conversation was outside, and then part was inside, is that right?
Yes.
Okay. Was she accompanied by anybody else from the district attorney's office, if you know?
I believe Mr. Hodgman was there, but I'm not sure.
You think Bill Hodgman was there?
I believe so.
And did he seem to come with her?
I have no idea.
And when she was talking to Furman, was Hodgman present?
If in fact he was there, yes. I believe that's where I saw him.
Okay. Now, did you see her talking with any other officers while she was there?
No.
Did you ever see any of the officers take her on a walkthrough of the premises at Rockingham while she was there?
No.
Were you, during most of this time, from the time you arrived there at 1:50 till 4:30, were you outside the premises and also inside?
Yes, on the first floor, and outside in the yard, and by the garage, mostly in the garage area.
And as I understand it, the instructions to Mr. Ford was to shoot any and everything that was recovered in the course of the search warrant, right?
No.
Did you understand that was what, did you come to know that was his understanding of what he was supposed to do that day?
That's not what,
That's what Ford said.
that's not what I told him.
That's not what you told him to do.
No.
You told him to shoot outside.
Right,
All right.
correct.
And then when you went inside, did some other detective talk to him?
Yes.
And who would that have been?
It's my partner, Detective Richard Harrow.
Harrow. Were you present when Harrow spoke with him?
No, I believe I had another assignment in the garage area, so I just left and turned him over to Harrow, so I don't know what they discussed.
You don't know what they discussed, right? Now, when Marsha Clark was out there, did you talk with her at all while she was
No.
there that day? Did you know who she was at that point?
Yes, I know Marcia.
You knew her from before.
Yes.
Have you seen any reports, any police reports generated in this case that would help us out on the times that Ms. Clark arrived, and who she talked to, and what she observed?
I have not personally, no.
Just a second, Your Honor. As I understand your testimony, Detective Harper, you never, while you were there, you don't recall seeing Marsha Clark leave the time she left.
No, I do not.
Did you see how she and Mr. Hodgman got there?
No, I did not.
Thank you very kindly, sir.
Ms. Lewis?
Detective Harper, were you present during the June 28th search warrant at Rockingham, the execution of that warrant?
Yes,
And Ms. Clark was present on that occasion as well?
yes.
Are you sure within your own mind that it was on the 13th that you saw her talking to Detective Furman rather than on the 28th?
Now that I reflect on it, it could have been on the 28th, but I remember seeing her there one of those days, either the 13th or the 28th.
But you're not positive which occasion it was?
Now that I think about it, no.
Your Honor, I believe the Bundy crime scene log has already been marked as an exhibit in this case. What is it? I can't read it. It has not? I don't know the number. But I do have another copy, albeit a little bit marked up. May I approach, Your Honor?
You may.
Detective Harper, looking at this other copy of what we know as the Bundy crime scene log from June 13th, do you see an entry on there of Marsha Clark arriving there at approximately, I think that says 2 o'clock or 2:02, and leaving at 2:15?
Bundy log.
Well, this copy is not the marked copy, it's been marked there.
It has the the court's copy. You may. And what exhibit number is that, Mr.
This is exhibit, I guess it's Defense 1006, 1006. And showing you this one, Detective Harper, it shows the same as the copy I just showed you, that Ms. Clark arrived at Bundy at 2:02 and left Bundy at 2:15.
Is that Bundy or Rockingham?
Bundy.
I was never
That's what this shows, though, right?
Yes, it does, but I was never at that.
This is the record speaks for itself. It doesn't help. He was never there.
All right, I already have it here.
Yeah, the court has heard previous testimony with regard to the Bundy crime scene log, so I'd ask the court to consider that evidence in conjunction with this hearing as well.
All right.
And to your knowledge, is it approximately a 5-minute drive from Bundy to Rockingham?
That's correct.
I think you just explained to us that your recollection as to between the 13th and the 28th is not real clear as far as when Ms. Clark was there. Is that correct?
That's correct.
And could it also be true that Mr. Hodgman was not present on the 13th but was present on the 28th?
Sustained.
What your recollection of seeing Mr. Hodgman is shaky as far as whether you saw him there on the 13th or the 28th. Is that fair?
The use of the word shaky, Your Honor. I'm not sure that's a very...
I understand what shaky means. I understand what it means.
Is that a fair statement, Detective?
Yes.
I have the crime scene log from the 28th of June, which I'd like to mark people's next in order, 159.
that's irrelevant until we talk about 13.
Overruled.
And council's had it for many months, so I'm sure it's on that occasion. We're going to do something. Detective Harper, showing you the log from Rockingham on June 28th. It shows your arrival time on here as 1500 hours or 3 o'clock in the afternoon. Is that an accurate assessment of the time that you arrived?
Yes.
And it shows you're leaving at 1816, I believe, which would be 6:16 p.m. Is that correct?
Yes.
And that's the time that you actually did leave on the 28th?
Yes.
So the time that you were there on the 13th roughly corresponds to the time you were there on the 28th in terms of both being in the afternoon hours, is that correct?
Yes.
And could that be one cause for your lack of perfect recollection as far as what took place on which occasion, as far as who was present?
That's true because I know I was there on both days and maybe I got them confused. So obviously I did.
Thank you. No further questions.
Just finally, as you sit here now, your best recollection is that Marsha Clark arrived at some time in the afternoon hours at the Rockingham residence. Is that correct? On June 13th.
I'm not sure if it was the 13th or the 28th now that I think about it, but I know one of those days she was there, and it was in the afternoon after I got there.
All right.
So
Before, on direct examination, you were fairly clear that she had arrived. You just weren't sure about Hodgman. Isn't that correct?
That's correct.
Because you remember that on the 13th, she had this conversation with Detective Furman. Remember that?
Objection mistakes the testimony.
Overruled.
Remember she talked to Furman on the 13th?
If one of those days, either the 28th or the 13th, and I'm not sure which day.
Was Furman there on the 28th?
I believe so. I saw him both days that I was there, the 13th and the 28th.
And was Roberts there on the 28th? If you know?
The 28th?
Yes, sir.
I'm not sure about that.
At any rate, now I want you to think back so we can give the court your absolute best recollection. On the 13th, the day this video was shot, the day after these bodies were found, you recall that Miss Marsha Clark was there at the Rockingham location between 2:30 and 3 o'clock or so in the afternoon. Do you recall that?
Objection.
You recall?
I can't lock myself into one of those days, or the 13th or the 28th, because now that I've thought about it, it could have been the 13th or it could have been the 28th.
Well, isn't it possible she was there on both times?
It's a possibility,
Right.
but I don't recall.
Do you recall her wearing a light-colored dress on the 13th?
I remember wearing a white dress, but I don't know which date it was.
All right. Thank you. I have nothing further at this point here. This witness.
All right, Detective Harper, thank you very much, sir.
May I approach? Just real briefly.
Keeping in mind what the issues are here,
Yes, Your Honor, just a couple of questions. Does the log from Rockingham on the 28th indicate Detective Furman was present on that date from 2:45 to 6:40 in the evening?
Yes, it does.
Thank you. Nothing further.
Nothing further, Detective Harper.
all right, thank you, Detective.
One other witness I'd like to call, Your Honor.
All right,
I'd like to call Marsha Clark instead.
all right. Ms. Clark?
Your Honor, I object to Ms. Clark being called to testify. As she's the lead trial lawyer in this case, it's not necessary. There's no evidence in the record at this point to support that she was ever there at the same time the videographer was there. I'm sorry.
Ms. Clark present, if you're going to
Well,
testify.
Ms. Clark certainly knows the issue. The testimony is that she left at approximately 2:50, I believe, or 2:50 or 3.
No, I would object to her making a statement. Ms. Clark's going to be called.
And the videographer arrived at about
Object.
3:10.
Noted. Overruled. All right, I don't need Ms. Clark's testimony as a witness. I simply need her statement to the court as to her recollection as when she was there, and more pertinently, when she found out this tape existed. And I accept that representation of any counsel here as officers of the court. I don't need it under oath from the witness stand. Good morning, Ms. Clark.
Good morning, brother.
I thought I had a day off. Yes, I can tell the court exactly when I arrived at Rockingham, and I would like to address this statement to Mr. Levin as well. But I arrived at Rockingham at about 12:30 or 1:45. I had earlier spoken with Detective Van Adder, who indicated he was going to seek a search warrant.
Is this the famous Harvey Levin time-stamped?
Exactly,
All right.
exactly, Your Honor. And Detective Van Adder had briefly told me what he had in terms of probable cause. I said, it sounds like you've got it. He said he'd present it to the judge, and he asked me to meet him at Rockingham. I said, well, there's no point in my going out there until you have the warrant signed and delivered. Please let me know when that's done. He called and he told me that, and that was at about 10:45, I believe. I was working on another case, and I didn't leave the office till about 12, and I arrived, I believe, 12:30, 1:45 at Rockingham. I met Detective Looper there. There were very few people there. It was everything very quiet, and apparently the defendant had already come and gone by the time I got there. Detective Looper walked me around a little bit. I think Detective Roberts did. I think Detective Furman did. On the 13th, I never sat outside at a table with anybody. I was there briefly. I made requests of them concerning what to photograph and in what sequence, and these are still photographs, in what sequence to photograph so that it would be understandable and clear, and asked them to make sure that they picked up certain items in the search. And he indicated to me, Detective Looper, that there was no search team available at the time. They were in a holding pattern for a while. I had other work to do, so I didn't wait for the search team, and I left Rockingham at about 5 minutes to 2. I had to go back down to the 10 freeway going east, so I took Bundy down, and the crime scene was on my way. And as is my habit, I always visit crime scenes to get a feeling for the spatial connections of everything and the dimensions. And I stopped by Bundy on my way back to the office at about 2 o'clock. I met with the officer who had the perimeter at that time. I don't remember his name, but the tape was still up, and he indicated no one was allowed inside, and I said fine. And I left very shortly thereafter. And I think the crime scene log reflects that I left Bundy. I was at Bundy from 2 to 2:15, that's correct. And I left Bundy at least at 2:15, if not 2:10. Went back to the office. At no time did I see a videographer present at Rockingham. I can assure the court that if I had, I would have been delighted, and I would have asked them to do one at Bundy as well. But I didn't know they were doing that. I did not learn of that videotape until a couple days ago when all of this, when the defense apparently indicated to us that it knew about a videotape, and then I asked, after having heard from someone else about it. That was in the last few days, very recent. So I never knew they had one, and I asked about it. I asked why, for what purpose they performed it and why we didn't know, and if they did one at Rockingham, why didn't they do one at Bundy? And the reason for that, they explained, is that...
I don't need to know the reason.
You already know. Okay. So I learned it was for administrative purposes, and that's all I knew. So I went to Rockingham first, and then I went to Bundy, and the crime scene log shows when I was at Bundy and indicates very clearly that I was not around when the videographer was there. And I've never... I saw the man come in to testify. Was that on Friday? I'd never seen him before in my life. So that was the first day I'd ever seen him.
All right, thank you, counsel. All right, I have before me, I take it, Mr. Cochran, have you completed presenting evidence?
I have no representation. I have no further witnesses at this point.
All right, people wish to present anything?
Wish to present the evidence?
Yes.
No, Your Honor.
All right, I have before me a defendant's request for sanctions, and including monetary sanctions and instructions to the jury. I'll hear argument.
Your Honor, I do want to note that I just received this at 9:15 this morning. I barely had time to read it, let alone confer with other counsel on the case in terms of responding to us. I would request an opportunity to respond.
I have no
mean, it's
objection.
a period of time during which you confer with my colleagues before responding.
I have no objection. It was filed this morning.
All right. Then I'll hear argument about at 4:30.
Well, 4:30 today may be a little tough, Your Honor. That's for obvious reasons.
Oh, I forgot. You're right. You're right.
4:30 would be tough today.
You're right.
1:30 or 4:30 today is a bad day.
You're right.
There is another hearing, I believe, at 1:30.
Right. And we need to be somewhere at 5:40.
Yes.
All right. All right, tomorrow then we'll take it up.
When was that, Your Honor?
Tomorrow. We have the motion on the coroner's testimony and motion on coroner's photographs today at 1:30.
1:30 today?
Yeah, okay.
You want to do 1:30 also?
Now let's do that tomorrow. All right, anything else before we invite the jurors to rejoin us?
Oh, Your Honor, I would move that Peoples 159 be admitted into evidence for purposes of this hearing, and Defense 1006 be considered for the hearing,
All right, they'll
as
be
well as 158.
they'll be accepted for purposes of the motion.
Your Honor,
Yes,
you want to
Mr.
take up the boards also before they're introduced to Dennis?
All right,
Mr. Newfeld, could you use microphone, please?
Yes.
all right. Who's going to be presenting Mr. Fung?
This man Goldberg will,
All
and I
right.
believe we're in the process of notifying him. And I also question Defense 1068 for purposes of this hearing.
All right.
They're here, their reports are on the way
What's the ETA?
Like the time the elevators take, which can be 5, 6, 7, 8 minutes.
All right, Madam Reporter, do we need to change? All right, let's change court reporters, and we'll start with the boards. Neufeld, you had some objection to some of the boards? All right, which board, what's your objection?
Your Honor, as you may recall, there was a ruling by Your Honor that the luminol testing and other presumptive tests would not be admissible as evidence for the presence of blood in this case. And one of the boards, unless there's independent confirmatory evidence of one sort or another, one of the boards depicts Mr. Fung standing next to a drain in a sink, holding up a Q-tip with a pink color on it to suggest that this was a positive result from a phenolphthalein test for the presence of blood. Number one, there was no confirmatory test on either of those items. Number two, as it's been already brought out to the court, and I think was the basis for the court's ruling, there are many other things which could test positive on those circumstances, particularly for the two drains, Your Honor. There is a vast body of literature which suggests that just normal bacteria and other microorganisms, the kinds of things that collect in wet drains and damp drains, would test positive. And it just has no basis being introduced or brought into this case at this time. The correct procedure would have been to take the contents out of those drains and bring them back to the laboratory and do some kind of test to confirm the presence of blood or to reject the presence of blood. And to our knowledge, that was never done. And I believe a lot of this you already know about from your initial ruling. So I would simply ask the court to instruct the people to remove those two photographs from the board.
Those are your objections?
Well, as to that one board, yes.
All right. Which board is that?
Would you like to see it?
Yes. Somebody want to give Mr. Fairtlow a hand here so we don't waste all our time? Is this the one you're speaking of?
Yes, Your Honor. It's this photograph here, which doesn't have a number on the photograph, so I can't say directly, but it's in the lower right-hand corner, and it's he's holding up a Q-tip next to a drain in the sink. I'd also point out, Your Honor, that the Q-tip itself has a reddish color, which would suggest blood, but it's not. The reddish color is the chemical reaction from the hydrogen peroxide. So it's even more prejudicial for that reason as well, Your Honor. So it's the drain shot here, and then there's a second drain shot, as you can see in the lower, there's two drain shots actually, in the lower left-hand corner. And I would ask that all three of those be taken out. Number 14, which is straight down at the bottom of the diagram, is in a different category because in 14 they actually did do follow-up testing at the laboratory, and so I think number 14 would fit within your Honor's exception, but the drain pictures do not.
All right. Mr. Goldberg?
Well, first of all, Your Honor, it would be nice if counsel would have given us some notice as to specifically what he had to object to on this board, since we have already plotted out what our direct examination is going to be, and as the court can now tell, it does involve presentation of evidence through the use of these boards. As to the phenolphthalein test results, I did not bring down my legal notebook because, again, I did not know that they were going to address this one specifically. What I would say is this, preliminarily. First of all, both sides have been introducing phenolphthalein testing throughout the trial in front of the jury, left and right. I'd point that out to the court, and that's why we are a little bit surprised by counsel's now objecting to it when I think both sides elicited that kind of evidence from the detectives. The other thing that I'd say is that the court did rule on the luminol test, but I don't recall the court making any ruling on phenolphthalein. There is a difference because the phenolphthalein test in this case is actually a two-stage process, which involves the use of phenolphthalein and then the addition of hydrogen peroxide, so it is more specific than any of the other presumptive blood tests, including luminol. So the court's ruling on one would not have any applicability to the other. And finally, in the case of People versus Coleman, and again, I didn't bring down my legal notebook, but it's a California Supreme Court case. The California Supreme Court discussed the issue of presumptive blood testing and says that it does come in, but there has to be some evidence as to what kind of a test you're talking about. In that case, a police officer who was not a criminalist used something that was called a heme stick, and he didn't really know what it was, and the Supreme Court didn't know what it was because there wasn't anything in the record. And they said that although in California there was a very lengthy history, and they cited several much earlier cases of forensic blood testing or presumptive blood testing coming in, that you had to have some evidence as to what the test was so that the court could determine whether it was one of the tests or one of the nature of tests that have been allowed in previous cases and that have been around for a while. So I think that the issue is pretty dispositively resolved in the state of California by our Supreme Court.
What's the side on Coleman?
Your Honor, as I said, I didn't bring down my legal notebook because I didn't know specifically that we were going to address this. Perhaps I could call up and have someone.
Do you anticipate getting to this board by the close of our session this morning?
I don't think I anticipate getting to this board by the close of business, Your Honor, this morning. But I do anticipate possibly discussing other phenolphthalein tests, such as on the Bronco. Now, I don't know whether the defense has any objection to those. In fact, I think that was already elicited.
All right. My recollection of our luminol testing is that we did not discuss phenolphthalein testing. All right. Mr. Neufeld?
Your Honor, we're not opposed to a reference to the fact that phenolphthalein testing was done. We're opposed to them introducing any of the results of that phenolphthalein testing. That's the difference here. To simply say that they tested various items, I mean, that goes without saying. It's one of the things they did. I don't understand the gentleman's point on the issue of the power of this presumptive test. It is widely known in the literature that this particular test is no more powerful or sensitive because it's a two-stage test. That's just the nature of the test, that the second thing you do is subject it to hydrogen peroxide to get a reaction. There is literature that not only talks about the presence of bacteria readily setting off a positive result, which is why most practitioners would never dare to use it in connection with a drain. But more importantly, Your Honor, there is additional literature which suggests that copper pipes, for instance, will give you that same kind of positive hit. It's very different to use a phenotest with drains and drain pipes than it is to use it with the wooden floor, for instance. we don't have that same risk involved, where you see the small reddish smear that you see in number 14. We don't have that situation here. My recollection was, and I'll have to check with the transcript, but that Your Honor did rule on the pheno test as well as the luminol test, and I may be mistaken about that, but that's the information I had before I stood up this morning.
All right, that does not comport with my recollection. However, my recollection could be inaccurate on that. But since Mr. Goldberg indicates that he won't get to that by the noon hour, we'll have the opportunity to check. All right, Mr. Goldberg, I'm going to direct you not to use this board until we have had the opportunity to resolve both the record and checking the Coleman case. And Mrs. Robertson, would you ask one of the law clerks to locate the Coleman case for me, please? All right.
You are also shown another board dealing with serology results. And not to waste the court's time at this point, if Mr. Goldberg can assure us that we're not going to get to the serology result board this morning, I can take that up later also. There are a variety of problems with certain specific results, and more broadly with the fact that he includes in the board inconclusive results. And since I've been practicing law, I've never seen a scientist report out results that he or she themselves deemed inconclusive. In fact, even in the reports in this case, technicians such as Yamauchi, for instance, will say, since the results were inconclusive, I will not make a statement about them in his reports. Yet on their board, they'll say things like inconclusive and then have in parentheses what the tentative results were. And I don't believe that tentative results, which are inconclusive to the technician, should see the light of day in a courtroom in front of the jury.
All right, Mr. Goldberg. Which board is this?
They're bringing it out now. It's called serology results.
All right.
Your Honor, on this particular board, the only inconclusive results that have been reported, as the court can see, with one exception, are under the category of EAP, or the erythrocyte acid phosphatase. The court may recall that in Mr. Cochran's opening statement, he claimed that there was blood under, or some biological material under the nails of Nicole Simpson. That is item number 84 on this board, and that it was a EAP type B, which was inconclusive with the defendant, who's a BA. The prosecution's position is going to be that we will demonstrate in a variety of ways, not only with conventional serology, but also with DNA testing, is that in fact what was tested underneath the fingernails of Nicole was her own blood. It can be done in a variety of ways, but part of that is what is represented on this board in the EAP category. Erythrocyte acid phosphatase is different from the other genetic markers that are used in the conventional systems in that, unlike PGM subtype, it involves not only looking at the banding pattern, but also the relative intensity of the bands, which means there's a level of subjectivity that's involved in interpreting it that is not involved in PGM subtype. The question of whether something is inconclusive or not inconclusive, therefore, involves a question that is somewhat subjective, and it's resolved by the analyst. What we are trying to show here, and will show, is that there is a situation going on at the crime scene at Bundy where we have a number of specimens that are in states of degradation with respect to the EAP system, and that we can demonstrate circumstantially that what is happening is that the EAP subtype is degrading from a BA to a B. And this board does that almost conclusively. The science articles indicate that one of the things that we can do, and one of the things that common sense would tell you can do, is you can look at a pool of blood under the victim, or blood on the victim's clothing, which you know circumstantially has to be hers. And if you can see evidence of degradation in that sample in the EAP system, it gives you a very clear indication of what would be going on with other blood of the victims, such as underneath her fingernails. So we see, for example, on this board that item 42, which is blood underneath Nicole, is an inconclusive B. Well, we know that's hers. It's her blood. So this provides very powerful circumstantial evidence as to the defendant's, as to the people's position that what we have under the fingernails is in fact degraded blood of the victim. This is a legitimate thing to do. It's a legitimate chain of circumstantial inferences for a jury to consider, and it's legitimate scientifically for our experts to consider this. I would point out that there's not a single instance here where an inconclusive result is being reported that inculpates the defendant. In other words, we don't have any reports of inconclusive results which are consistent with the defendant's EAP type and PGM subtype, which is a BA, and his PGM subtype is a 2+, 2-. In other words, we're not using any inconclusive results for the purposes of showing that his blood is at the scene. We're using them for the purposes of showing that Nicole's blood is under her fingernails, and it's completely unobjectionable. I find.
Why should I allow tentative results?
What?
Well, you say that these are inconclusive but indicative of.
Well, no. INC stands for inconclusive. What that means is that when the analyst looks at the PGM subtype plate or the EAP plate, it's a gel, and there's a certain banding pattern that results, that he is not comfortable enough with that subjectively to say, in fact, it is a B. In fact, it is a BA. What he is saying is that's what it looks like, but I'm not comfortable enough to make that call with certainty. What he will be able to say is he will be able to say that based upon a variety of results, and I'm not telling it to the court in as much detail as will be presented. Hopefully I won't need to for the purpose of this legal argument. What he will be able to say is that based upon the combination of what he sees happening with the EAP results at this scene, that there is very powerful circumstantial evidence that the EAP results under Nicole's fingernails, in fact, is likely to have been or may have been a BA that degraded into a B. And when the jury sees it, they will be able to come to that conclusion on their own, even without the benefit of expert testimony. That's what this board does.
All right, thank you, counsel.
Yeah, may I respond on part of
Nope.
that?
Mr. Neufeld.
Your Honor, one second. He's missing a fundamental point here, and the fundamental point is that scientists do not make a habit. In fact, they never report out in a court of law, and I'm sure this is your own experience as well, on results that they can't stand behind. Period. Whether it's to some degree of reasonable scientific certainty or some other comparable standard, they don't report out items which to themselves are inconclusive. It's not a question of even being tentative. Let me give you just as an example. I'll just pass up.
Mr. Neufeld, but let's talk about the specific here. Don't we have a problem created by the fact that in the defense opening argument, this particular piece of evidence was argued to be something, and then a excerpt of a police report or the criminalist report is put up and displayed to the jury and purported to have a certain result inconsistent with the parties here, whereas the actual testing indicates something that's different.
No,
Has-
it doesn't, Your Honor, and that's the point. Here, for instance, is the analyzed evidence report in this case, and you can just take a look at it. What's the proper?
No, I've seen it.
Okay. And what it says is that the serologists themselves called the blood scrapings underneath her fingernails a B. Not an inconclusive, not a tentative, a B. Whereas all these other items, they didn't call at all. And they said, we will not make a statement on them because in our opinion they are inconclusive. So there's a very significant distinction between the serologist's professional approach to calling the blood scrapings beneath her fingernails as a B and all these other characterizations which are inconclusive and for which the serologist did not want to make any call at all.
But shouldn't the jury know that these items were tested and the results are these, they're inconclusive? Isn't the jury entitled to know that?
Oh, the jury is entitled to know that they were inconclusive. I'm not disputing that. They can just say inconclusive. Our dispute, Your Honor, is a suggestion they were inconclusive but looks like an A, inconclusive but looks like a B, inconclusive but looks like a BA, as is reflected on that board. The fact that the examiner said it's inconclusive means that he or she is not willing to report out the actual result other than to say it's inconclusive. That's how scientists work. That's how technicians work. And this document belies that professional approach, which is used nationwide by all technicians and scientists who do this exact kind of testing. That's the difference. In fact, in the actual report here, they don't say it looks a little bit like a B or it looks a little bit like an AB on the inconclusives. They give no answer. They just say inconclusive. Whereas for the typing of Nicole Brown Simpson's fingernails, they say specifically and unequivocally at this point in this statement, it's a B. That's the difference. So we don't have a problem with them simply saying inconclusive. The problem is them trying to hook the inconclusive with a tentative result, when the scientists themselves would never do that and don't do that.
Mr. Goldberg?
Well, see, they want to try to structure what Mr. Matheson's opinion is going to be and what he bases that opinion on. That's for the expert to decide. That's not really a legal issue. It is a scientific one. What they want, why are they so upset about this? Because this almost conclusively proves that our theory is right and theirs is wrong. Because the mere fact that these are inconclusive Bs or BAs shows that there is degradation, which is the very thing that we want to show. So saying it's inconclusive, that doesn't show anything. It doesn't demonstrate.
When do you plan on using this?
What?
When do you plan on using this board?
This would be used with Mr. Matheson, which would be towards the very tail end of my portion of the evidence that I'm presenting.
All right. I'll think about this one then.
Well, could I finish?
We're not even going to get to Mr. Fung, through Mr. Fung this week, I suspect. Who's first?
Mr. Fung. Well, I don't know, because they have never given me a clear indication of how long they feel it's going to take on cross-examination. But obviously, we would like the problem resolved, Your Honor, and we feel very, very strongly about this, because this is going to give Ms. Clark the opportunity in her closing argument to stand before the jury and say, look, we can show you what's happening on the scene, and we can show you that the blood under her fingernails degraded. It's the only common sense,
My inclination,
logical
Mr.
explanation.
Goldberg, is to wait until I hear Mr. Matheson's testimony.
In a pretrial type, outside the presence of the jury,
Right. Do you intend on using this in front of the jury?
with Mr. Matheson only.
Yes.
With
All right.
Mr. Matheson only.
Let's proceed with Mr. Fung, I understand, as your next witness.
Finally, Your Honor, the only other objection we have at this time on the boards is there's a series of boards which try and reflect the movement of certain items of evidence, beginning on June 13th, right through August, September, October. And it would be our objection to displaying the board to the jury, or at least admitting those portions of the board until a proper foundation is laid by the prosecutor. In other words, if Mr. Fung can only testify about the handling of evidence on June 13th and June 14th, then the rest of the board, which talks about those items that he collected being sent off in August, September, October, or whenever to other laboratories, that should not be on the board when it's shown to the jury at that time.
Mr. Goldberg?
I don't understand the legal basis of the objection. Is this like the peekaboo rule in the evidence code? Your Honor, perhaps we can show the court the board that counsel is referring to. There is absolutely nothing that is remotely prejudicial, or for that matter, even terribly interesting about these boards. It is simply a way of being able to establish something that would otherwise be extremely tedious, boring, and time-consuming, and this way is only going to be slightly tedious, boring, and time-consuming. And that is when the evidence came in and when it went out. And we just have photographs to depict all the evidence indicating its original packaging when it was received and the transmittal envelopes.
All right, I'm looking at a large display board entitled LAPD Evidence Disposition Summary.
This board is probably going to be testified to in part by a number of different witnesses, including Mr. Fung and Ms. Mazzola would be testifying mostly to the items or exclusively to the items in the left-hand side of the column next to their names. Then Mr. Matheson would be testifying to certain items. Mr. Yamauchi would be testifying to mostly the items in the cell marked DOJ and FBI columns, which were the ones that he prepared. And then subsequently, when the witnesses come in from those laboratories, they will be testifying off the board. So it's sort of a board that, in order to lay the foundation for, there are a large number of people that have to do it. But I see no reason to cover up those parts that pertain only to the witness that is testifying at the given time while we do it. The jury can't even see what's on the other photographs.
Mr. Goldberg is suggesting that there's a tedious exception to the hearsay rule. All we're simply saying is that under the laws of California, one has to lay a proper foundation before evidence can be introduced and exhibited to the jury. And obviously, Mr. Fung and Ms. Mazzola are not the witnesses who can lay the proper foundation, suggesting this continual chain of certain items to these other laboratories. As Your Honor is well aware, the defense is going to vigorously challenge the chain of custody in this case, has so in prior proceedings, and will continue to during this trial. And this exhibit makes it all seem like it happened in a very straightforward fashion, but obviously the initial witnesses are not competent to testify to the subsequent chain of custody and transfer of various items at a time and place where they weren't involved.
All right, thank you, counsel. The objection is overruled. At this time, the prosecution can use this exhibit with the understanding that there'll be a motion to strike if they don't tie it all up at the end of the conclusion of the trial.
Your Honor, let me address one more issue, unless counsel had more questions on the boards.
No, he sat down, so I assume that means no.
Okay.
And also, before we start with this new phase, Mr. Shapiro and Ms. Clark, I would suggest that you reintroduce to the jury the new members of the teams, so to speak, sitting at counsel table so that they know who they are and what their purpose is for being here. All right. Mr. Goldberg.
Thank you. One of the witnesses that we're going to be calling is Colin Yamauchi, who did some testing in this case on the 14th and 15th, and also some conventional testing later in June. And in addition, is almost exclusively the witness that will testify to the bulk of the chain of custody in terms of packaging items for the purposes of being shipped out to certain laboratories, with only a few exceptions. What we would like to do is we would like to divide his testimony up, as I discussed with counsel on Friday, into two parts and call him once during the chain of custody portion of the case, and then again later on to discuss his DNA results that occurred on the 14th and 15th. The way that I would propose that working, and I discussed this proposal with counsel, was Mr. Yamauchi would testify that on the 14th of June, he went into the evidence control unit, the evidence processing room, where the evidence was located, and he took certain samplings of that evidence, and then took that evidence to the serology laboratory to begin his analysis. His direct examination would effectively then end at that point, and then skip to the 15th when he took an additional set of samples, describe how he sampled them, walk them up to the laboratory door, in effect, and then skip over to the next relevant point in his testimony with those two spots, the blank spots, so to speak, involving the actual testing to be presented later. So we would ask the court's permission to allow us to do that. I'm not sure whether counsel objects to that. And if the court is inclined to allow us to do that, and I don't see any reason why the court wouldn't be, there is another issue that I'd like to discuss with respect to whether a certain...
All right, counsel, let's talk about this when we have Mr. Yamauchi testify. I've had the jury sitting back here now for almost 2 hours, and this is something we don't need to decide right now.
Okay.
All right, let's have the jurors.
Your Honor, this is 15 seconds, if I could.
Does it have to do with Mr. Fung?
No, Your Honor. No.
No.
This afternoon. Save me a minute this afternoon.
All right. my apologies to you for having kept you so long. As I indicated to you last week, we are going to now change the focus of the case to the actual collection and testing of the evidence in this case. And I indicated to you there were a number of preliminary issues that I had to determine to see what evidence was going to be presented to you. And just for example, this morning I've taken 6 pages of notes just on the hearings that we've had today. So we've been hard at work since 8:30 this morning, and I just wanted you to know that we know that you're back there waiting for us. We have some new attorneys present in the courtroom for this phase of the trial, and Ms. Clark, let me start with you. Do you wish to introduce the members of your team who will be presenting this evidence?
Yes, thank you very much. Good morning, ladies and gentlemen. I've introduced these members of the team at the time of our opening statement, but it's been a long time since then. You've probably forgotten. This is Mr. Hank Goldberg,
Good morning.
and this is Mr. Woody Clark, and this is Mr. Rock Harmon. These gentlemen will be presenting the evidence concerning the physical evidence, the collection of it, and the analysis of it, both for conventional serology and for the analysis of DNA.
Thank you, Ms. Clark. Mr. Shapiro.
Thank you very much, Your Honor. Good morning, ladies and gentlemen. We have 3 lawyers who will be assisting us in this phase of the evidence. Mr. Peter Neufeld, who has been with us since the beginning, but is making his first appearance before the jury.
Morning.
Mr. Barry Scheck, who has also been with us from the beginning and making his first appearance here.
Morning.
And Mr. Robert Blazier, who has been a member of our team and will be aiding in the presentation of the evidence and cross-examination of expert witnesses.
Good morning.
Thank you.
Thank you,
Thank
counsel.
you, Your Honor.
All right, the people's next witness.
Call Dennis Fung to the stand.
All right.
Raise your right hand, please. You do solemnly swear that the testimony you make give in the cause now pleading before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat in the witness stand and state and spell your first and last names for the record.
My name is Dennis Fung, D-E-N-N-I-S-F-U-N-G.
Mr. Goldberg.
Thank you, Your Honor. Good morning, Mr. Fung. What is your occupation and your assignment?
I am a criminalist employed by the Los Angeles Police Department. I am assigned to the Firearms Analysis Unit of the Scientific Investigation Division.
And that's for the LAPD?
Yes.
Right. And were you so employed on June the 13th of 1994?
Yes, I was.
Sir, on June the 13th of 1994, were you responsible for collecting certain evidence at 360 North Rockingham and 875 Bundy in the city of Los Angeles?
Yes.
And later on June the 14th, were you responsible for collecting certain evidence in a Bronco that had been impounded from the Rockingham location?
Yes.
Now, before getting into that, I'd like to ask you some questions about your training and experience. First of all, you said you're a criminalist.
Yes.
What is a criminalist, sir?
A criminalist is somebody who employs the principles of the natural and physical sciences to identify, document, preserve, and analyze evidence that is related to a crime. He later testifies to his findings in a court of law.
And is a criminalist someone then who is involved in the area of forensic sciences?
Yes.
What does that term forensic sciences include?
The forensics sciences is the discipline that employs or uses natural and physical sciences such as chemistry, biology, physics, and just about any other science you can think of to determine issues related to a court of law.
So it's basically a broad group of different kinds of sciences that are brought to bear to resolve issues regarding evidence in a courtroom?
Yes.
All right. In order to become a criminalist, did you have to have some formal education?
Yes, I did.
And where did that take place?
I received a Bachelor of Science degree in criminalistics from the California State University at Long Beach.
So that's a 4-year degree?
Yes, it is.
Okay, and did you receive any other bachelor's degree at the California State University, Long Beach?
Yes, I did. I also received a Bachelor of Arts degree in chemistry from the California State University at Long Beach.
And when was that?
That was in 1985.
When you were going through college, particularly during the criminalistics portion of your formal education, did you process mock crime scenes?
Yes, I did.
All right. And while you were going to college, did you have any internship that you went through?
Yes, I did an internship at the Orange County Sheriff's Office Crime Lab.
Approximately when was that?
That was approximately September of 1982 to December of 1982.
Okay. And did the Sheriff's Department in Orange County employ criminalists?
Yes, they did. Or do.
Did you ever have an opportunity when you were interning with them to go out to crime scenes and see the way crime scenes were processed?
Yes.
When you went out to crime scenes that were processed by the Sheriff's Department in Orange County, were they processed by criminalists or did they use some other category of personnel?
Their crime scenes that were not homicides were processed by forensic specialists.
Okay, is that what they called them?
Yes.
And what is a forensic specialist?
A forensic specialist is somebody who goes out to crime scenes and takes photographs and collects evidence and documents the evidence also.
Do they have the same formal education that you have in order to become a criminalist?
I don't believe the requirements are the same, no.
Okay. Is there any similar category of person that's employed by the Los Angeles Police Department?
No.
Okay. So LAPD is using criminalists at their crime scenes?
Yes.
Now, within the local law enforcement community here in Southern California, are there also people that are called evidence technicians?
Yes.
And what are they?
Evidence technicians are people who will go out to crime scenes and collect evidence and document the evidence also.
Okay. When you were at Orange County, did you have the opportunity to see criminalists working in the laboratory setting?
Yes,
Right. But you just didn't see them working in the field?
that's correct, yes.
All right. Now, in addition to the formal education and training that you just described, have you also continued to take courses related to the field of criminalistics since you graduated?
Yes, I have.
Okay. And have you taken seminars by the American Academy of Forensic Sciences?
Yes.
And by the, what is that?
The American Academy of Forensic Sciences is a professional organization of forensic scientists. They deal specifically with topics related to my field.
Okay. And have you also taken courses through the California Association of Criminalists?
Yes.
And what is the California Association of Criminalists?
The California Association of Criminalists is another professional organization dealing with forensic sciences.
Do you have a curricula vitae that summarizes your formal education and some of the courses that you've taken since you graduated?
Yes, I do.
And do you have memorized all the courses you took and when you took them, or would you need to refer to that to give us some more specific information?
I would have to refer to them.
Can you please do so?
Yes.
Sir, have you taken quite a few courses since you graduated in the area of criminalistics?
Yes.
I'd like to ask you about just selected courses from your curricula vitae and have you give a little information about these, the ones that are relevant to crime scene investigation. In 1985, did you take a course in blood spatter interpretation at LAPD?
Yes, I did.
And what was that?
That involved the recognition of different blood pattern interpretation that we might find out at crime scenes.
Like blood drops and blood spatters and the like?
Yes.
And for what purpose do criminalists look at that kind of information?
A criminalist would look at that type of information to determine the direction from which a blood was traveling, or whether it was made by a gunshot or maybe a smaller, or a gunshot, or was made by an object swimming and having the blood fall off of that object.
Okay. And in February of 1985, did you take a course in forensic microscopy?
Yes, I did.
What was that course about?
That course dealt with the trace evidence, such as fibers and minerals and explosives.
Okay, and what's trace evidence?
Trace evidence is small particles of evidence, such as hair, fiber, soil, and glass, that type of evidence.
What purpose do criminalists look at trace evidence? Are you comparing it to something, knowns to unknowns, or?
Yes, it's comparing knowns to unknowns,
Okay.
or identifying what something is in certain other cases.
Okay. And then in 1989, you took an advanced course in forensic microscopy, is that correct?
Yes,
So that would be a continuation of what you just described in terms of learning about trace evidence.
yes.
Okay. And these kinds of courses, the two courses in forensic microscopy, how do those equate with the college level criminalistics course?
They're just as rigorous.
So how many unit equivalent would you say, if you can give us that kind of information, would these courses be to the ones that you took at Cal State Long Beach?
4-unit class.
How many?
4-unit class.
Okay. And in 1987, you took a course in footwear identification.
Yes.
What was that course about?
That was a course to identify shoe print impressions to a known source. If, for instance, if I had a shoe print at a crime scene and a known shoe or an unknown shoe that came into the lab, I would be able to identify that shoe as having made that shoe print.
Or being consistent with it?
Yes.
All right. And you also took some seminars with the American Academy of Forensic Sciences. One of those was in 1991, is that true?
Yes.
And did that particular seminar discuss, to your recollection, crime scene investigation?
Yes.
All right. And in 1990, you took a seminar at the California Association of Criminalists.
Yes.
Did that discuss any aspect of crime scene investigation, to your recall?
Yes, it did.
Do you remember at all what was discussed there?
In the 1991,
1990?
1990, I believe that was one that was involved with the Night Stalker case that was discussed at that seminar.
Okay, and then in 88, you also attended a California Association of Criminalists meeting.
Yes.
And did that discuss crime scene processing that you recall?
Yes, it did.
Okay, now with respect to the other meetings that you also attended of either the American Academy or the California Association of Criminalists that we didn't specifically mention but that are listed on your curricula vitae, do you recall one way or the other whether they discussed crime scene investigation particularly?
No, I don't recall one way or the other.
What kinds of things in general are discussed at these meetings in the seminar portions?
In the seminars, analysis of different types of evidence are discussed, as well as legal issues, and sometimes crime scene investigation is also discussed.
Okay. And are you a member of the California Association of Criminalists?
Yes, I am.
And when did you become a member?
I became a member in late 1984.
Are you a member of any other professional associations?
Yes, I am.
Which one or ones?
I am a member of the Association of Firearm and Tool Mark Examiners.
How many years have you been a member of that?
Since 1992.
Now, I'd like to discuss some of your on-the-job experience at LAPD. First of all, when did you become a criminalist at the Los Angeles Police Department?
I became a criminalist in October of 1984.
Okay, and you also listed the various sections of the laboratory that you've been assigned to at various times on your curricula vitae.
Yes.
In 1994 through 87, excuse me, where were you assigned?
I was assigned to the toxicology unit from 1984 to 1987.
And what is toxicology?
Toxicology is the analysis of biological fluids for the presence of toxins or drugs.
When you say biological fluids, what kinds of fluids were you typically analyzing?
In our lab, we typically analyze urine and blood.
So you were dealing with biological specimens while you were at toxicology?
Yes.
And was there any training or any experience that you feel was particularly relevant in terms of crime scene processing that you got as a result of being in toxicology?
In toxicology, basic laboratory principles were employed, such as labeling, cleanliness, hygiene, and the appreciation for the being aware of cross-contamination issues.
When you say cross-contamination, what are you referring to?
That refers to mixing one sample with another or contaminating one sample with another sample.
I mean like one blood sample with another blood sample?
Yes.
Okay. And in 1987 through 89, you were assigned to trace,
Yes.
and you've already described to us what trace evidence is.
Yes.
Is there anything about being assigned to the trace evidence section of the laboratory that you feel was relevant in terms of your experience in investigating a crime scene?
The trace analysis unit gave me an appreciation for what trace evidence can do for an investigation, such as hair, fiber, and paint. That type of evidence can be very helpful sometimes in an investigation.
Do you also have to be aware of the proper packaging and labeling of
Yes.
specimens? Would that also be true of toxicology, that's important?
Yes.
Okay. What about cross-contamination of samples? Is that an issue in trace?
Yes, it is.
Okay. And after you were assigned to trace, you then went to firearms?
Yes.
Is that where you are now?
Yes.
What is your exact title position in the criminalistics laboratory?
I am the Criminalist 3 assigned to the Firearms Analysis Unit.
Okay, and are there also criminalist 1s and criminalist 2s?
Yes.
When did you become a criminalist 3?
I became a Criminalist 3 in January of 1994.
What are the LAPD requirements for becoming a criminalist 3?
The requirements are 3 units of expertise in the field of criminalistics and 5 years on the job.
Well, when you say 3 units of expertise, what do you mean by that?
The lab is broken up into different sections, and to be a criminalist 3, you have to be court qualified in 3 of those different sections.
So in your case, was it toxicology, trace, and firearms?
Yes.
Okay. And is there any test that's required or examination process that's required in order to become a criminalist 3?
Yes, there's a written and oral examination given by the laboratory.
What is the difference between a criminalist 3 and a criminalist 1 and criminalist 2?
A criminalist 1 is a entry-level position. A criminalist 2 is a journey-level position, and a criminalist 3 is a lead position.
Okay, so when you first come to the laboratory, you're a criminalist 1?
Yes.
On the date of June the 13th, you were working with Andrea Mazzola,
Yes, I was.
and was she a criminalist 1?
Yes.
Okay. In terms of the duties of criminalists at crime scenes, what is the difference between a criminalist 1 and a criminalist 2 and 3?
A criminalist 1 knows the technical aspects of crime scene investigation. However, in our laboratory, a criminalist 1 will go out with a criminalist 3, and if any discretionary calls are needed to be made, a criminalist 3 will make them.
So a criminalist 1 has to be paired with a criminalist 3 at crime scenes under the current policies of the Los Angeles Police Department.
Yes.
When you were first starting out and you were a criminalist 1, was that also true?
The structure was a little bit different then, but I was always escorted by either a supervisor or a more experienced criminalist in the laboratory.
Meaning someone 2 or higher?
Yes.
All right. Now, during that process, when you were a criminalist 1, were you receiving on-the-job experience and training then from the more experienced people in terms of how to investigate a crime scene?
Yes.
Okay.
The quality of it and the quantity of it.
Okay, well, let's break that down. What do you mean by location?
By location, I mean where it is in relation to where the crime occurred. If there was a blood stain, for instance, 3 miles away, and then that would be a less significant stain if it could not be related back to the crime.
Okay, so you're trying to look for stains that would appear to be more relevant than other stains when you're talking about location?
Yes.
Okay, what about when you're talking about quantity? What are you referring to there?
By quantity, I would be looking for something that we would be able to analyze. A sufficient amount would be necessary to make some type of determination.
Okay, and what about quality?
By quality, I mean something that is not likely to be contaminated or degraded.
When you use the term contaminated, what does that term mean?
Contamination, in the broadest sense, can be bringing something into an environment that is unwanted or undesirable.
Well, if you were using the broader definition of contamination that you've just provided us with, could you look at the suspect's blood at a crime scene itself as being contamination in that sense?
In that sense, yes.
Is blood now classified as being a biohazard?
Yes, it is.
All right. Well, is there a more narrow or precise definition of contamination that is also used in the area of criminalistics?
Yes. As it relates to the evidence, contamination can also mean bringing a substance to a crime scene that would compromise the evidence and somehow affect the conclusions of an analysis.
Okay. So those are the various factors that you take into consideration that you just discussed with us in terms of deciding what biological evidence to collect and not to collect?
Yes.
If you have a trail of blood drops, do you necessarily collect every drop in the trail?
Not necessarily, no.
Okay, so then do you use the representative sample rule that you discussed earlier?
Yes.
All right. And what about debris at a crime scene? How do you go about deciding what types of debris to collect or not to collect?
With debris, I will try to collect things that are foreign or out of place to the location.
So you wouldn't pick up every single piece of trash that happened to exist at a crime scene?
No.
Or do you draw a certain diameter around the body and pick up every piece of trash within a certain diameter?
In certain instances I may, but not necessarily, no.
So if it's something that looks out of place, you might collect it?
Yes.
What about clothing? How do you go about deciding what clothing to collect or not to collect?
With clothing, I will try to identify items that seem out of place or in a strange location or may have some help in the investigation of a crime.
Okay, so again, it sounds like these kinds of decisions are common sense type decisions. Would that be correct?
Educated guesses, yes.
Okay. Directing your attention now back to June the 13th of 1994. At approximately 5:30 or so in the morning, did you receive a call?
Yes, I did.
Where were you when you received that call?
I was at home.
Okay. And what was the nature of the call?
It was a call from Criminalist Missoula informing me that there was a homicide we were requested to respond to in the West LA division.
Okay. And what did you have to do after receiving that call?
After receiving the call, I made arrangements with Criminalist Missoula to meet me at the laboratory.
Okay. If you're the supervisor, why did Criminalist Missoula call you?
Criminalist Missoula was the primary criminalist on call that weekend.
Incidentally, is that her official designation, criminalist?
Yes.
Okay. And is she a trainee?
No, she's a criminalist.
Okay, so when you join the lab and become a criminalist, you're a full-fledged criminalist?
Yes.
All right. Now, where did you meet up with Criminalist Missoula?
I met Criminalist Missoula at the Piper Tech laboratory that morning.
Where is Piper Tech?
Piper Tech is at 555 Ramirez Street. It's about a mile away from Parker Center.
And why did you have to meet there as opposed to going directly to the crime scene, did you say?
I met her there so that we could meet and get the crime scene truck to respond to the location.
Okay. How many crime scene trucks does the Los Angeles Police Department have?
For the homicide criminalist, there was only one truck.
All right. Your Honor, at this time, I'd like to mark people's next in order.
160.
160, and it is a picture of the what would appear to be the Los Angeles Police Department criminalistics truck, which counsel has a copy of.
All right, proceed.
Your Honor, I'm going to place a 160 on the reverse side of this photograph. May I place this on the Elmo so that the
Yes.
witness and jury can see it? Court counsel, please. Name on it. Okay, sir, directing your attention to the picture that's above you, I guess you can see that from where you're sitting?
Yes.
Okay. What is that?
The truck to the left is the crime scene investigation truck.
Okay. What about the one that's over to the right that says hazardous chemicals? What's that?
That is another response team in the laboratory for hazardous chemical response.
Okay, so the truck that you were taking with criminalist Mazzola was the one that's primarily featured on this photograph on the left?
Yes.
Okay. And where did you, that's fine, thank you. Where did you take that truck to?
We brought that truck to 360 North Rockingham.
Now, while you were in transit, was there any paperwork that you began filling out at the in the truck?
Yes.
What was that?
That was the crime scene investigation checklist.
Okay. Your Honor, at this time I'd like to mark as People's 161 a document that's entitled Crime Scene Investigation Checklist.
All right, 161.
And for counsel's benefit, it's L10. Just one page. It's just the face page. Can we see that? Okay. Can we see it up here?
Main monitor, please.
Sir, directing your attention to the document that we've just marked as People's 161 for identification. Do you recognize that?
Yes, I do.
Okay, and on that document, there is a notation that says OIC name. It's about 6 lines down from the top.
Yes.
Who is filled in there?
That is A. Mazzola, or
Or-
criminalist Mazzola's name.
Okay, and what does OIC mean?
OIC is the acronym for Officer in Charge.
Okay, by the way, why do you call it OIC, or Officer in Charge?
That's just police vernacular for who's taking responsibility.
But technically, you're not sworn personnel, are you, criminalists?
That's correct.
All right. Now, why was Andrea Mazzola's name put in that location where it says OIC?
Ms. Mazzola was the primary criminalist on call that weekend, and it was going to be her responsibility to take care of the paperwork and direct some of the SID people to perform their functions.
Well, what other SID people would be at a crime scene that you would have responsibility for directing?
The photographer and the print specialists are under SID.
And did you anticipate while you were driving to the Rockingham location that Andrea Mazzola was in fact going to be the officer in charge in that sense?
Yes.
Okay. Thank you. Now, at some point, Mr. Fung, did that anticipation change?
Yes, it did.
When was that?
After I had received the briefing by Detective Van Adder, it was determined that I would be the OIC at that crime scene,
Okay.
as far as the search team was concerned.
What time did you arrive at the Rockingham location?
I arrived there at 7:10 in the morning.
Okay, and why did you decide that you were going to become the person in charge of the investigation as opposed to Andrea Mazzola?
When I found out that it was a high-profile case and it was going to be a complicated scene, I decided that she should, in a sense, take the back seat.
Now, just so I can understand the relationship between a criminalist 1 and a criminalist 3, let's say that you had arrived at a crime scene with criminalist Mazzola that was fairly simple, routine, very little evidence to collect. What would the relationship between criminalist Mazzola and yourself have been at that kind of a scene?
Criminalist Mazzola would have determined the type of evidence that she would have collected and taken about the more procedural functions, such as directing the photographer as to what type of photographs he should take and directing the print examiners to the specific items to be printed at the scene.
Okay, so if it had been a simple scene, you would have allowed criminalist Mazzola to make these kinds of discretionary type decisions that you described earlier in your testimony regarding what to collect and what not to collect?
Under my supervision, yes.
Okay, well, what if you saw her making a mistake?
If I saw her making a mistake, I would tell her about it and correct her procedure.
Okay. Now, let's say that we were talking about a very simple scene where there wasn't a lot of evidence to collect, and you were working with Andrea Mazzola, and there was a dispute between the two of you. She says, why don't you collect that? You say, no, you collect that. No, you collect that. No, you collect. Or any other kind of a dispute. Who's going to win in that kind of a dispute?
Criminalist 3 takes precedent, and the criminalist 1 will have to do what the criminalist 1 will have to do what the criminalist 3 says.
So even at a simple crime scene, are you still designated then as being Andrea Mazzola's supervisor in that sense?
Yes.
Okay. Now, at this particular crime scene at Rockingham, was there ever a time where Andrea Mazzola did direct crime scene photographers
No.
or print people
No.
or anyone else that you saw?
No.
And what about at the location at Bundy?
No. She did not have any opportunity to direct anybody at that scene.
At both scenes, were you telling her what items to collect and what not to collect?
Yes.
Okay. Now, after you arrived at the location at Rockingham at approximately, said 7:10 a.m., what was the very first thing that you did when you got there?
The first thing I did was I was met by Detective Van Adder, and he gave me a briefing as to what he had at the crime scene and what he wanted me to do.
Did he show you any evidence?
Yes, he did.
What did he show you?
He showed me a red stain on the driver door of the Bronco and a blood trail leading from the Bronco towards the front entrance of the residence.
Okay. Did you notice anything about the temperature at that time, or the weather?
It was fairly cool.
What about the lawns? Did you notice anything that looked like it could have been dew on the lawns?
I did notice that there was the grass was wet.
All right. And after the items of evidence were pointed out by Detective Van Adder, how did you go about collecting them? Did you do it alone, or did Ms. Mazzola help you? How did that work?
Ms. Mazzola and I worked as a team to document and collect the evidence.
Now, in terms of collecting biological evidence, particularly blood, have you been trained in how to do that in the standard technique that's used within the LAPD?
Yes.
Okay. And did you use that technique at the location of Rockingham for the purposes of collecting the evidence?
Yes, I did.
Your Honor, at this time I'd like to mark as People's 162 for identification a board that is entitled Collecting a Stain Demonstration.
All right, People's 162.
Which I'd like to put up. And I'd also like to mark as People's 163 for identification a brown paper bag and its contents And I'd like there's a document in there that I'd like marked as People's 163A. This document is an inventory, Your Honor, that itemizes all of the contents of the bag as being A through L, People's 163A being the exhibit itself, the inventory.
Yes.
And I already pre-marked the items inside the bag. Mr. Fung, can you see this board from where you're standing?
I can't see. I'd have to get up.
Okay. With the court's permission, can the
Yes.
witness? Yeah. Okay, sir.
Can I stand over there?
Perhaps we can pull up the photograph that's marked number 1 on People's 163.
Would you please?
Sir, does People's 163 demonstrate most of the major steps that are involved in collecting a stain?
Yes, it does.
And directing your attention to the photograph that's numbered 1 on this board that says number and measure stains, what does that photograph depict?
That depicts the documentation portion of the collection of a stain. We will number the stain with an identification number and then measure the stain as to its location and then have it photographed.
And this particular demonstration, who is portrayed in the photograph that's marked, that's labeled as 2, and the rest of the photographs?
That's Criminals Mazzola.
Okay, can we see number 2? Directing your attention to photograph number 2, what step does this involve?
This involves the collection of the control. In this photograph, she is selecting a cloth swatch and dampening it with distilled water.
Sir, I'd like to show you what we've marked as People's 163E for identification. It's a coin envelope containing a bindle. Can you open up that bindle and tell us what's inside of it?
I'm opening up the bindle, unfolding it, and within the bindle are 3 cloth swatches.
Your Honor, perhaps I can put this on the Elmo as well so that the jury can take a look at that.
All right, let's give it a try.
Yeah. Okay, you can kind of see them. Well, now I guess they look more like tablecloths than swatches. But, Mr. Fung, what is represented here on the this exhibit?
You can see 3 cloth swatches in that. I guess it's a projection.
Okay. Your Honor, perhaps we could pass it around to the jury just so they could get a sense of how small the item is. Thank you. They should be warned, though, they have to be careful, otherwise they're going to lose some of
not
our
to
swatches
sneeze.
here.
Yes. Start with your number 1, please. The record should reflect that all the jurors have had the opportunity to observe the contents of 163E.
Maybe you can refold that for us, Mr. Fung, so we don't lose them. Okay, so in photograph number 2, maybe we can get that back up again. You are, that's showing her dampening these little tiny swatches that the jury has just seen.
Yes.
And how is she holding the swatches?
The swatches are held with a pair of tweezers.
Okay. And what is she dampening them with?
She's dampening them with distilled water.
All right. Now, directing your attention to the cell number 3 on our collecting the stain board, People's 162.
After she dampens the cloth swatch, she applies that swatch to an area very close to the stain.
Okay, so on this photograph, it actually looks like she's missing the stain number 5 by what could be about an inch or so.
Yes.
And why is she doing that?
She's doing that so that she will get a representative substrate control.
Okay, what does the term substrate refer to in this term that you've just used, substrate control?
The substrate is the object from which we are collecting a stain. In this case, it's a sidewalk. However, it could be a wall or a table. It's whatever we're collecting the stain from.
And what does the term control refer to?
Control refers to the process of looking for something that will somehow affect the conclusions of an analysis. So if there was some type of interfering substance on the sidewalk here, it should show up in the substrate control.
Does the substrate control serve any other purpose other than trying to tell you what might be on the substrate, if anything?
There are other side benefits in performing a substrate control. One of them is that our instruments and materials used to collect the samples are also checked during this process, and our technique to some degree is checked by the performance of collecting a substrate control.
Okay, so in other words, if the substrate control came up clean, that might provide some indication that your techniques in terms of collecting the stains were proper?
Yes.
Okay, but if it comes up dirty, does that necessarily mean, well, I'm not sure if dirty is the scientifically correct word, but if you test it and you find some biological evidence on there, what does that tell you, if anything?
That could indicate that there was also some type of biological substance on the substrate itself.
Meaning on the sidewalk in this particular demonstration.
Yes.
And that is the purpose of the substrate control, its intended purpose. All right, and why it's called substrate control.
Yes.
Okay. Now, after the substrate control is collected, what does she do with the substrate control?
The cloth swatch used to create the substrate control is put in a plastic baggie.
Okay. Sir, I'd like to show you a plastic baggie that I've just removed from People's 163E for identification. Do you recognize that particular type of material?
Yes, I do.
Now, what's that?
This is the type of bag that we use to place the cloth swatch in once it has been applied to the sidewalk.
Okay, so after collecting this cloth swatch that may have nothing on it, she then puts it into the plastic baggie.
Yes.
And is that shown in photograph number 4, if we can have that up?
Yes, it is.
Okay, so she has the plastic baggie there in her right hand, it appears, and she's putting it in the coin envelope that's being held in her left.
Yes.
Now, how does she get the cloth swatch into the plastic baggie?
She puts them in with a pair of tweezers.
Okay. And then what does she do with it?
The plastic bag is placed in the labeled coin envelope, and she goes on to the next step.
Okay, maybe you can replace the plastic baggie in there now that we've seen what that looks like. Now, directing your attention to cell 5, labeled clean tweezers. Can we have that up there?
One, please. Name model.
What is depicted in this cell?
That depicts criminal Smazzola cleaning her tweezers.
Okay, now how does she clean them?
She will wet a tissue with distilled water and wipe the tweezers on the moistened part of the tissue to wipe away any type of material that may be present on the tweezers.
So why do you have to clean the tweezers now if you've only collected the substrate control?
The tweezers are cleaned just as a matter of hygiene or lab practice, good lab practice.
Are you handling the substrate control then in exactly the same way you'd handle a stain, just as if it were a stain?
Yes.
All right. Now, directing your attention to the cell that's numbered 6 that says take new swatch, then dampen it. What does that show?
That depicts criminal Smazzola selecting a swatch which is approximately the correct size to transfer the stain onto it. She will select a swatch, dampen it, and with a pair of tweezers apply it to the stain and let the stain absorb onto the cloth swatch.
Okay, now, in number 6, she appears to have taken a swatch out of a little, what looks like a pill bottle. Is that right?
Yes.
And you say that she has to select one that's the right size. What do you mean by that?
When she's collecting, or when we collect blood stains, it's important not to collect a stain onto a swatch that's too large. Otherwise, the stain will be dilute and more difficult to analyze.
Is that why you're using these little tiny swatches that the jury has just seen?
Yes.
Because you want it to be as concentrated as it can be?
Yes.
All right. Now, directing your attention to the cell that's labeled number 6 that says collect stain, and in parentheses has number card removed, if we could have that. What is Ms. Mazzola doing here?
Ms. Mazzola is applying the cloth swatch to the stain itself.
So now she's actually collecting the stain.
Yes.
And in this case, it's the one that was numbered 5.
Yes.
All right. And she does that simply by applying the dampened cloth swatch to the stain itself.
Yes.
Now, directing your attention to the photograph that's in cell 8, what does that depict her doing?
That depicts her placing the cloth swatch in a plastic bag and then placing the plastic bag in the coin envelope.
And does that go in the very same coin envelope
Yes.
that you already put the substrate control in?
Yes.
And so you have a coin envelope that has a stain in one plastic bag and then a control in another plastic bag.
Yes.
And the coin envelope would be numbered to correspond with the number card?
Yes.
Okay. Thank you. You may resume your seat. Sir, just following up then on the collection procedure, if you're collecting consecutive stains, let's say 5, and then you went on to collect stain 6, using the standard procedure that you've just described, how many times are you going to clean the tweezers between collecting stain number 5 and stain number 6?
All told,
Yes.
four times.
No, between the two stains?
Oh, between the two
Yeah.
stains, once.
All right. Well, if you collect the, let's just see if we can get the sequence down, but between two stains. Let's say that you've collected the stain number 5.
Yes,
Okay. Then the next thing that you're going to do on number 6 is collect the substrate control.
yes,
Will you have cleaned your tweezers before doing that?
yes,
All right. And then you'd package up substrate control number 6,
yes,
and now you're going to collect stain number 6.
yes,
Okay, before collecting stain number 6, will you have cleaned your tweezers again?
yes,
Right. So it's twice under the standard practice that you clean the tweezers
yes,
between stains.
yes.
All right. If someone varies that practice by collecting the tweezers an extra time, I'm sorry, cleaning the tweezers an extra time, is that something that's over and above the standard practice that you're using in LAPD?
Yes.
All right. Okay, so is the procedure that you just described the same general procedure that was used to collect the stains at Rockingham?
Yes, it is.
All right. Your Honor, I'd like to mark as my next exhibit People's 164 for identification. A diagram I'm sorry, it's already been marked. I'd like to use what's already been marked as People's 120, which is a diagram of Rockingham.
All right, People's 120.
Mr. Fung, perhaps you can step down if you need to take a closer look. Have you had an opportunity to look at this board before today?
Yes, I have.
And the photographs in it as well?
Yes.
Okay. Now, directing your attention to photograph A on this board, there are in that photograph what appear to be little tiny cards in the street and on the driveway. What do those cards represent?
Those represent items of evidence or tags for items of evidence that we were going to document.
Okay, so these are the cards that you used when you were previously describing, I think, what was step number 1 on the demonstration, numbering and measuring the stains.
Yeah.
I would object that testimony is being conclusory. It testifies specifically to what he was saying.
Sustain, rephrase the question.
Okay, these are the cards that you used.
Yes.
Yeah. And are these cards that you put out or that Andrea Mazzola put out in your presence?
Yes.
Right. And for what?
Object to that is being vague.
Overruled.
You should say particular.
Overruled.
And
That's
for what
not-
purpose?
Wait, It's not an appropriate objection. Proceed.
Thank you. Sir, and for what purpose were these cards put out?
The cards were put out to mark items of evidence or locations that we wanted documented.
Okay, now, there's also a call-out line that goes from the photographs that are labeled A and B on this diagram. What does that call-out line portray the general area that you saw these two stains? The stains in A and B?
Yes.
Okay, one's in the street, the other one is in the driveway.
Yes.
All right. Now, if you look closely now at the photograph that's marked C on this diagram, here we can have that one. I don't know if the resolution on the large one is good enough, but Mr. Fung, maybe you can take another look at the smaller photograph over here that's C. Can you actually see the numbers on the cards?
Yes, I can.
And do those cards represent stain number 5 and 6? Well, there's 5, 6, and then there's a letter.
Yes.
Okay. And directing your attention to the call-out line from that photograph, does that demonstrate the general area where these 3 stains were located?
Yes, it does.
And with respect to the photograph that's marked D on this diagram, does that represent stain number 8 as portrayed in the, is that an 8?
That's a B.
Oh, I'm sorry, a B. Okay. And does the call-out line show where B was?
Yes. Approximately, yes.
Okay. And now, looking at the photograph that's marked F on this diagram,
Yes.
what does that show?
That shows the stain that we labeled C.
Okay. And now, looking at photograph I. Maybe we can have I. Which stain is depicted in I?
That is number 7.
Okay. And does the call-out line represent the general area where 7 was collected from?
Yes, it does.
And now directing your attention to photograph K. What does that depict?
That depicts the location where number 8 was collected.
Okay. And the call-out line on that?
Yes.
Okay. You can resume your seat. Now, did you collect a stain on the car door of a Bronco that was located at the Rockingham location?
Yes.
Do you have to, in order to tell us times that various stains were collected, refer to something, or did you memorize that?
I would have to refer to notes.
What type of document would you have to refer to?
There's an evidence collection sheet that we fill out.
Is that the crime scene identification check, part of the crime scene identification checklist?
Yes.
Okay, that was the document that we put up earlier that had, that we were talking about in terms of who was in the box or the line locate across from where it says OIC, officer in charge.
Yes.
And when is that particular document filled out? Is it at the crime scene or after?
The certain portion, well, most every portion is filled out at the crime scene.
Okay. So the portions documenting the numbers that you collected and their locations, when are they filled out?
Those are filled out at the crime scene.
Do you know who took the measurements of the various items here that are listed in the crime scene identification checklist?
Both Criminalist Mazzola and myself were working as a team to measure these items of evidence.
So you worked together in that?
Yes.
And with respect to the times that are written down there, as to the evidence collection that occurred at Rockingham the morning of the 13th, when were those filled out?
Those were filled out at approximately the same time that they were collected.
So they are not exact?
No, they're not.
All right. Approximately how many pages of documentation, including the crime scene identification checklist, did you generate in this case in connection with the evidence that you collected, would you say?
There were approximately 80 sheets of notes and reports generated.
Have you had an opportunity to look those over prior to your testimony?
Yes, I have.
And are there some clerical errors in some of those reports and notes?
Yes, there are.
Okay. When you're at the crime scene, do you fill these particular documents out? Well, did you fill this particular document out? I'm referring to the Rockingham crime scene identification checklist in pen or in pencil.
This, I believe, was done in pencil.
And why would you use a pencil as opposed to a pen?
If a mistake was made, then you could easily erase it and put in the correct information.
So it's a document that you are filling out in the field,
Yes.
and if there's a mistake, you simply erase and then write over it.
Yes.
Okay. Now, can you tell us at approximately what time the item on the Bronco door was recovered?
That was recovered at approximately 8:15 in the morning.
Now, perhaps I can put that exhibit up. It's People 62B, I believe. What does People 62B for identification depict?
That depicts me pointing at the stain
Okay,
that
and-
was on the door handle, or near the door handle.
And that's what was collected at approximately 8:15 or so in the morning?
Yes.
Now, when you were at the Bronco that morning, could you see any other blood inside of the Bronco?
I did see what appeared to be stains in the interior portion of the vehicle.
Where were you standing when you saw those?
I was standing at the front passenger window.
So on the other side of the vehicle, as depicted in this photograph, People 62B?
Yes.
Right. And what did you see when you were looking in?
I saw some reddish stains on the console and near the window ledge of the driver door.
Was there enough light for you to be able to see the floorboard on the driver's side?
I could see the driver's floorboard, but I couldn't make anything out.
On it?
That's correct.
Okay. Now, with respect to stains 4 through 6, what time were those collected approximately?
Stains 4 through 6 were collected approximately 9 o'clock.
And 7 through 8, approximately when were those collected?
7 and 8 were collected approximately 9:15.
Now, when you were looking at the various blood dots that you previously described that are depicted on the diagram here that's been previously marked as Peoples 120 for identification. Did any of those blood dots appear to be stepped in?
No.
What condition did they appear to be in?
They appeared to be dry, and they had a reddish tinge to them. They appeared fresh.
Okay.
All right, Mr. Goldberg, would this be an appropriate point?
It would, Your Honor.
All right. How about if you take that exhibit down for me real quick? All right, ladies and gentlemen, we're going to take our recess for the morning session. Please remember all of my admonitions to you. Do not discuss the case amongst yourselves. Do not form any opinions about the case. Do not conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. Counsel, we will stand in recess until 1:30, and let me see counsel without the reporter at the sidebar. All right, Mr. Fung, you're to return 1:30. Defendants again present before the court with his counsel. People are represented. See, we have a new addition, Brian Kelberg, on behalf of the people. Good afternoon, sir. All right, we have two motions on for this afternoon. One has to do with the cross-examination of Dr. Golden. The other has to do with admissibility of autopsy photographs. Mr. Kelberg.
Your Honor, if it would please the court and counsel, I prefer to address the Dr. Golden motion first.
All right. Two issues as to Dr. Golden.
Correct. And I did receive counsel's response filed, I believe, on Friday. As I understand it, defense's response was not filed under seal. I've heard some public commentary regarding it. Ours was filed under seal, and of course I assume the court has had an opportunity to review what we say in our brief. Let me begin by acknowledging what is a somewhat difficult position for me, and especially somewhat difficult because my colleague, Mr. Harmon, is sitting right behind me. I think the court probably recognized, if it reviewed Mr. Harmon's motion regarding the scope of cross-examination of experts, and review my motion concerning the scope of cross-examination of experts, that we seem to be talking about the same topic, but seem to reach very different views of what the law is in this area. And I think it's clear to say that Mr. Harmon didn't consult me when he filed his motion, and I think it's clear that I did not consult him when Mr. Lynch, who is sitting, I don't know if the court has met Mr. Lynch, but Mr. Lynch is my colleague who has assisted me ably on these motions, along with Ms. Lewis on the photographic motion, that we did not consult Mr. Harmon. I say this because I believe that in testing expert testimony, one should test it on the merits of the science or the medicine. And I believe the law supports that position. And as a result of my perspective, I do not believe that one's personal use of drugs when the person is not a percipient witness, and the question may be whether the person's perceptions or ability to perceive or recollect were affected by drugs, that becomes an issue. And I carry that over, and I realize that there is this dichotomy, and probably I won't ride in the same elevator back with Mr. Harmon after court this afternoon. He's given valued assistance to our office from Alameda. But the law is the law, at least as I see it, and it applies whether it's my motion, Mr. Harmon's motion, or a defense motion. So I have to begin with that caveat. It's a somewhat difficult position. I believe our position on the law is the state of the law on scope of cross-examination of an expert. Let me begin then with the alleged gun incident of Dr. Golden. The fact that just a week ago the Academy Awards were given out and Tom Hanks won for the second year in a row caused me to review the movie for which he won the Oscar the year before, Philadelphia. And I think the court may have seen the movie and may recall a scene near the end when Tom Hanks is dying of AIDS. He's at his hospital bed dying when his lawyer Denzel Washington comes to report the success from a big verdict that the jury has rendered in his wrongful discharge suit. And at that time, Tom Hanks whispers a joke to Denzel Washington which as Denzel Washington is leaving the hospital, he enters an elevator where there's a patient in a wheelchair and a cervical collar, and he repeats the joke to that patient. What do you call 1,000 lawyers chained together at the bottom of the ocean? And before Denzel Washington can even give the patient the punchline, the patient, with a bit of a sardonic smile, provides it, a good start. It is unfortunate, Your Honor, that the legal profession has a perception in the population at large that is something less than favorable. It is clear that we have perhaps only ourselves to blame, that we sometimes use trick and artifice, it seems, in cross-examination or direct examination, and cause witnesses to be made to look foolish when in fact it's a very credible and truthful witness. So we do have only ourselves to blame for this perception. And the incident involving Dr. Golden, even if the incident occurred in a way which is the most favorable to the defense, that is a real weapon and the threat being made regarding taking out lawyers, that does not show bias against these lawyers. After all, Mr. Hodgman, the prosecutor at the preliminary hearing, is a lawyer. We are lawyers. If anything, at its best, such evidence merely suggests what is a nationally held view, that you could take 1,000 and a whole lot more lawyers, chain them to the bottom of the ocean, and society might be the better for it. I have a different view. This court was a lawyer for many years. I've been a lawyer for many years. Defense counsel have been lawyers for far many years more than I have. And I don't think any of us would be in this if it were not an honorable profession. And I speak of that both from this side of the table and from that side of the table, because someone who is very near and dear to me practices law from that side of the table, not this side of the table. And so when the public has this concern about lawyers, it bothers me. But if the issue is, did Dr. Golden make mistakes in the way he performed the autopsy? How is this view of lawyering going to assist a jury in deciding whether mistakes were made or not? Let me tell this court, there is no question mistakes were made, and we're going to bring out those mistakes. There is nothing to hide when one looks at the evidence. And we have no fear that when all of the evidence is out and all of the evidence is presented to this jury, that they will make a fair and rational decision. Because although in Dean Ullman's response, I think to the photographic motion, he used the pejorative term incompetency, number one, that's not a term we used, and that is not a term which is going to apply to what Dr. Golden did. But when you use a term like incompetency as a pejorative, it conveys an image that not only were mistakes made, but they really matter. They go to the heart of cause of death, manner of death. Was there one killer, multiple killers? How did these people bleed? Should blood be on the perpetrator, and so forth? Well, what the evidence is going to show, and I have the utmost confidence my colleagues will be able to argue successfully to this jury, is that whatever mistakes Dr. Golden made, they do not impact on any issue in this case. Let me use the most well-known example. Everybody talks about, my God, he threw away the stomach contents of Nicole Brown Simpson. What an idiotic thing to do. Well, I think it's fair to say the evidence will show she did not die of food poisoning from Mezzaluna Restaurant. And she did not die from drug intoxication from taking too many barbiturates that are still in her stomach. If one wants to look at the medical reasons why one would save the stomach contents, then that is a perfectly fair issue to present to this jury. And I submit when the evidence is out, there is no medical issue that warranted saving that contents. Because the evidence will show that Dr. Golden did what any sound forensic pathologist examining a body in this situation would do. He opened the stomach, he examined its contents, he wrote it down contemporaneously to his examination. And the form will be in evidence for all the world to see that he, not by just luck, but by competency, examined and found rigatoni in Nicole Brown Simpson's stomach and found the volume to be 500 cc's. And this court may remember when Ms. Clark was examining, I believe Tia Gavin is the server's name, somebody came in, I guess at the lunch hour, with some document in response to an SDT, which Ms. Clark didn't have the foggiest idea about. And that's my responsibility, because I thought, getting into the case somewhat belatedly, that, gee, it might be interesting to see. Was it a lucky guess by Dr. Golden that she had rigatoni in her stomach? Or did he, in fact, make an accurate observation? And lo and behold, as the evidence has already shown, he made an accurate observation. And that the evidence will further show, Your Honor, that when someone is able to identify intact food in the stomach, not what I say, not what Dr. Golden says, but, for example, one of the most recognized forensic pathology texts in use in this country, Spitz and Fisher, I'll give them a plug, Spitz and Fisher, Medical Legal Investigation of Death, 3rd edition. What do they say? And what's the evidence going to show? It's going to show it has been found that stomach contents which are readily identifiable by naked eye inspection were usually ingested within a 2-hour period. And of course, the court will recall the testimony is that Ms. Brown left the restaurant between 8:30 and 9. One witness said 8:45-ish. And I assume that my colleagues will argue to the jury that it is reasonable to assume that one doesn't put in the last bite of food and in the next breath take the first step out of the restaurant. If one is talking about 10:15 versus 11 o'clock, we don't need Dr. Golden's incident with the gun to test the stomach contents and to test the significance of that stomach contents. And in fact, what is some of the strongest evidence on stomach contents comes from the words under oath of the defense expert that Mr. Cochran has indicated to this jury they will hear from, Dr. Bodden, who in a 1988 case for the prosecution said that the time of death where he was able to identify intact pieces of potato and meat with clear margins around the food, indicating lack of digestive process, that indicated death less than 1 hour from the time of eating. And Dr. Bodden's view is that the stomach empties in something like or less than 2 hours, which may or may not be medically correct. But nevertheless, from the words of their own expert, the evidence of the stomach contents will show that the time of death is in fact consistent with 10:15 and not consistent with 11 o'clock. So in spite of everybody talking about stomach contents and throwing them away, there's only one reason the stomach contents should have been saved in this case, as the evidence will show. To cover the backside of Dr. Golden so that Dr. Bodden could have examined it. It's defensive medicine. In the practice of clinical medicine, it's doing unnecessary tests to protect the doctor from being sued when there's an adverse outcome. But if the issue is going to be the medical judgment and the medical findings that that evidence can support, there is no question that we are confident that the evidence will support the view that the stomach contents, if to be used at all for estimating time of death, supports 10:15 and refutes 11 o'clock. We don't need this alleged animosity towards lawyers to test that. Now, this is assuming that the incident occurred the way it did. The evidence is anything but clear that the incident occurred that way. In fact, there's an issue. Is it a real gun or a toy gun? Is it said in jest? And most importantly, who's it in reference to? The lawyers in the Simpson case? This is a comment allegedly made 13 days after Dr. Golden testified at the preliminary hearing. 13 days. Now, if Dr. Golden felt that he was subjected to what Dean Ullman calls a blistering cross-examination by Mr. Shapiro, I have to say, I've read it, I've watched it, and if that's blistering, I can only imagine how Dean Ullman would characterize Mr. Douglas's cross-examination of Mr. Shipp or Mr. Bailey's cross-examination of the two police officers. I would assume he'd use a term like thermonuclear. The point is that if Dr. Golden were so upset, you would have had an incident that day, that night, the next day. We know, I think the court could almost take judicial notice that coroners perform autopsies, one, perhaps two autopsies, every working day they're there when they're not testifying in court. And so when they're testifying in court, they're being hassled by a lot of lawyers. DAs, defense attorneys, they want them there at a particular time, the doctor can't be there. They want to talk to them in advance to see what they're going to say, the doctor doesn't have the time. There is this inherent tension between their responsibilities and our responsibilities. And I say our, I mean the legal profession, not just prosecutors. And so any animosity he might have, if it in fact exists, is against the process in general, is not shown to be against these lawyers. And in fact, it is a classic 352 circumstance for which cross-examination should be precluded. We are going to have to litigate what happened. Dr. Golden does in fact have a Fifth Amendment privilege, and in fact one of the cases that I pulled up this morning, the Jennings case, I think is particularly important, 53 Cal 3rd 334, page 371, where the court noted that the fact that evidence would consume a considerable period of time, especially because the witnesses would probably invoke the Fifth Amendment, necessitating appointment of independent counsel for them, was a valid basis for the court to say, forget it. 352, let's keep it out. And incidentally, Dean Ullman in his response does not point out the United States Supreme Court decisions such as Delaware versus Van Arsdale, which I can give the court a citation to. I'm sorry. And the California Supreme Court cases which follow it, which say that there's nothing inherently inconsistent between a court exercising its discretion under 352 to exclude basically irrelevant, prejudicial in the wrong sense of the term prejudicial evidence, and having the defendant an opportunity for his cross-examination under the Sixth. There is no inconsistency whatsoever. If we're going to spend the time litigating the facts that surround the incident with Dr. Golden, then I suggest to the court we divert the attention away from the jury's understanding of the medical issues involved. Now, perhaps the defense prefers that, but it seems to me where on direct examination many mistakes will be brought out from Dr. Golden, and we will assess the medical and scientific impact of those mistakes, that this incident involving animosity is simply the kind of thing that should be excluded. And if it's not excluded, think what the court buys itself into. Prior consistent statements, 791, 1236, because the contention is that the bias arose as a result of the blistering cross-examination of Mr. Shapiro. Therefore, his preliminary hearing testimony, his grand jury testimony, where they are consistent with his testimony at trial and prior to the formation of the alleged bias that is the subject of this collateral matter, become admissible under 791 and 1236. I don't think it helps anyone to spend the time going over that. We should be talking about science and medicine, not talking about prior consistent statements about matters that really have nothing to do with the bottom line issues of the reliability and validity of the findings. That is my view on the incident involving the gun. Does the court want me to go on then to the other two?
Yes, please go on to the other incidents.
Okay. The other incidents, again, 1990 incidents, where Dr. Golden made certain mistakes. He misdiagnosed, I'm not sure is the correct word, he opined regarding entry and exit wounds in an incorrect fashion, and he was involved in a determination of distance regarding where a gun was at the time the shot was fired, which turned out to be erroneous. Our position on the law is very clear, Your Honor. These are specific acts of alleged conduct which do not reflect a course on credibility, moral turpitude. They are not prior felony convictions, etc. So they are not admissible because they only serve to create the impression that he has a character trait for being an incompetent physician, a negligent physician, and that he acted in conformity with that. The classic 1104 of the Evidence Code prohibition. Now, I thought it was interesting that Dean Ullman cites a federal case, and by the way, there's a subsequent Colorado case, I can give the court the citation, which refuses to follow it. But the interesting thing about the federal case is you've got an expert testifying for the plaintiff in a malpractice action, and the expert is going to be asked and is asked Number one, if he had inflated his invoices when being an expert witness, and he testified he had. Now that I have no disagreement with. If somebody does that, that's an act that reflects on truth and veracity under Wheeler. Specific act, not barred because of Prop 8, and it bears on truth and veracity. That's fraud. I mean, plain and simple. The other thing was he'd been sued 3 times in medical malpractice actions, and the court said that was fair game on credibility. But the rule that was cited by the court is 608B of the Federal Rules of Evidence. 608B is a rule analogous to the Wheeler decision. It deals with specific acts of misconduct offered on the issue of truth and veracity. And what's interesting is this decision is, I think, 91. In 1986, the United States Supreme Court, in a case called U.S. versus Abel, which I can give the court the citation if it wishes, had to decide whether 608B and the limits on cross-examination with specific acts of misconduct on truth and veracity also barred cross-examination on specific acts that reflected not on truth and veracity, but on bias, which is the argument that Dean Ullman makes in his response papers, that in response to the first incident of the gun, that it reflects his bias. The decision in the federal case is dealing with the malpractice actions, and yet the court cites 608B. And I don't think anybody suggests that being sued in a malpractice action reflects a lack of truth and veracity on the part of the doctor. But by relying on that section, the court has, I believe, mischaracterized what the legitimate purpose would be if there were a legitimate purpose. Our position is that the case we cite, Hinson, addresses this clearly for what it is. It is mistakes that are made in the past create an impression that you have a character trait to act in a sloppy fashion. You acted in conformity with that character trait. Ipso facto, you must have been negligent in this case. Well, this stuff is so excludable under 352 for the very reason that Dr. Golden is going to admit to his mistakes, or that his mistakes are going to be shown. There's not going to be a question as to whether or not he made mistakes. You don't need this evidence. It's the very kind of evidence 352 is intended to exclude. It's not the issue for this jury. This jury is going to have to decide not whether mistakes were made, but the significance of any mistakes, if there is any significance. And on that, his prior mistakes will shed no light whatsoever. Now, of course, you've got classic 352 problems, and these are old, 4.5, 5 years ago. They deal with 2 cases out of 6,500 that he's done. They deal with gunshot wounds, not stab wounds. What do? Do we litigate the merits of those 2 cases, litigate the merits of the 6,498 that the defense doesn't have any evidence to suggest he did improperly? Or do we litigate the merits of what he did in this case and focus, as I believe we can, on what the literature shows, what the research material shows, and what other people who practice in the area believe with respect to these issues, as well as Dr. Golden's view. So bottom line, Your Honor, is Hinson is apposite, not inapposite. The federal case is obviously not a ruling that really reflects what the true state of the law is that they cite for their proposition that this evidence is admissible past medical malpractice complaints. And the evidence should be excluded so that we can focus on what is important and let the jury make an honest call, whatever way it is. Because I won't be here at the end of the case when it's argued, and there are other people in this office that have a lot of interest in how it comes out, but I'm going to be perfectly candid with this court. Since I'm not arguing the case, once I'm done, I'm out of here, and it's not soon enough for me. I would have preferred Mr. Hodgman's health that permitted him to be down here. So I don't care whichever way the jury goes, as long as they make an honest decision on the evidence and not be misled. The last thing I leave you with is just, I have considered how some of these witnesses must have felt after they left their experience as witnesses in this case. And I got to feel that Mr. Kalin is not going to send Ms. Clark a Christmas card unless he does so because he hears some DA making a comment that he wouldn't do so, and he'll show otherwise. And there are other witnesses who I sure feel that they were excoriated by the defense in cross-examination in an unfair way. Do we honor the profession? Do we honor the practice of law and what law is supposed to stand for? If we deviate into these little tributaries of irrelevant baloney, I suggest that if the defense can prove that Dr. Golden made mistakes that significantly impacted on any issue in this case, they've got the resources to bring in some top guns to try and show that. And we'll cross-examine them and test their ability. One last thing, I'm sorry that I forgot, because I think it's the Bible. I do not hold myself out as an expert on the Bible, but I believe there's a phrase that says something to the effect, let he who has not sinned cast the first stone. Dr. Bodden, our foremost pathologist, according to Mr. Cochran, has made a few mistakes of his own, as the evidence would show. Let me focus on one that I think may be relevant if the court believes Dr. Golden's mistakes are relevant. Dr. Bodden, when he was in New York as a medical examiner, signed off on a death of an alcoholic.
Let me just interrupt you. I don't really want to go down that road at this
Okay,
point.
that's fine, Your Honor. I think the court clearly understands what we submit should be the real issues and why we believe these extraneous matters do not serve a search for the truth, which I've always understood, at least in our Izizaga prosecutorial discovery days, is what a trial is intended to be, a search for the truth. So on that basis, we believe that our motion is well taken and it should be granted as it is spelled out. Thank you, Your Honor.
Mr. Ullman.
We, of course, are interested in a search for the truth as well, and we subscribe to the aphorism that the best engine in the search for the truth is cross-examination. And what this motion really addresses is what opportunity the defense will be given to cross-examine an expert witness as to areas with respect to his qualifications, his bias, the credibility, and the weight that the jury should give to his testimony. There are essentially two items of evidence in question here. First, on July 21st, 1994, 13 days after he got off of the witness stand in the preliminary hearing of this matter, Dr. Golden was seen displaying a firearm on the premises of the Los Angeles County Coroner's Office and was heard to remark, "You know, we ought to go out and kill 9 or 10 of those attorneys." The other item relates to the fact that, and it's conceded, on 2 prior autopsies, Dr. Golden made serious errors in examining the character of wounds. In one case, mischaracterizing entry wounds and exit wounds completely backwards, and in the other case, indicating that a shot was fired from several feet away when in fact it was a contact wound. Now, with respect to all of this evidence, what we're talking about is the weight and the credibility that the jury is going to give to the testimony of Dr. Golden with respect to some very key issues in this case, including the time of death, including the nature of the wounds, whether the wounds indicate that they were made by 2 different weapons, as Dr. Golden indicated in his preliminary testimony. And when ultimately, what we were just treated to really was akin to what we're going to hear in closing arguments. I know Mr. Kelberg indicates he won't be here for the closing argument, but I think we got a pretty good preview of what we can expect when the jury is asked to weigh the credibility of opposing expert witnesses. And I assume that Your Honor will instruct the jury in conformity with Section 2.80 of the Calgic instructions that you may consider the opinion with the reasons given for it, if any, by the expert who gives the opinion. You may also consider the qualifications and credibility of the expert. You are not bound to accept an expert opinion as conclusive, but should give to it the weight to which you find it to be entitled. Now, the only guide that the jury is going to have to approach that function of determining what weight they should give to the opinions of the experts is what they heard in cross-examination of those experts with respect to their qualifications and with respect to their credibility. And the evidence code clearly recognizes that when we're dealing with expert witnesses, we have to test their credibility in ways that we don't test the credibility of normal witnesses. Section 721 of the Evidence Code provides that a witness testifying as an expert may be cross-examined to the same extent as other witnesses, and, in addition, may be fully cross-examined as to his qualifications, the subject to which his expert testimony relates, and the matter upon which his opinion is based, and the reasons for his opinion. And the California cases make it quite clear in applying that rule that we give the greatest and widest latitude to the cross-examination of expert witnesses, more than we do in the case of any other witness. Now, Mr. Kelberg repeatedly mischaracterizes the nature of this evidence as bad character evidence. And that simply is not the principal grounds of relevance, although even on that issue, his argument is simply incorrect. He is arguing that the only bad character that can be used to attack a witness is a felony conviction. And that is simply not true anymore in the wake of Proposition 8, which provides that all relevant evidence is admissible.
I think that's what I heard.
I can assure the court that's not what I said. Wheeler
No,
clearly
now,
stands.
counsel, I'm not addressing you, Mr. Gilbert.
Sorry, Your Honor.
I'm
All
just
right.
indicating that's not what I heard.
Well, the theory on which this evidence is going to be offered is not that it is evidence of Dr. Golden's bad character and that the jury should disbelieve him because he is a bad man who doesn't conform to the regulations about bringing firearms to his place of
Dean
employment.
Ullman, let's cut to the chase. What it's interesting about is an expression of bias against perhaps these attorneys and a demonstration of professional incompetence.
Well, let me address those separately. First of all, the expression of bias. It is more than just an expression of bias. I think it's relevant to both 780F, which relates to bias and hostility, and 780J, which relates to an attitude toward the giving of testimony, which doesn't necessarily have to relate to a specific feeling of hostility or favor to one side or the other. 780J addresses a more general attitude about the giving of testimony. Now, what Mr. Kelberg is saying essentially is we have an explanation for what Dr. Golden did. Our explanation is that all he was expressing is general animosity toward the legal profession in general, or perhaps he was making a joke. Well, that's an explanation that should come from Dr. Golden. We certainly have a good faith basis to ask him what he meant by a statement about we ought to go out and kill 9 or 10 of those attorneys. We think there is ample indication in the record that at the time that statement was made, it was shortly after Dr. Golden had been subjected to cross-examination. We have information not reflected in these statements that at the time this incident occurred, Dr. Golden mentioned Mr. Shapiro by name. We know that at the very moment this statement was made, Dr. Golden was being subjected to intense media scrutiny, that a television special was being prepared about Dr. Golden and his competence in a long series of cases. So there's ample reason for us, it's not paranoia, Your Honor, for us to believe that Dr. Golden was talking about us when he said, I ought to go out and shoot 9 or 10 of those attorneys, that those attorneys are the 9 or 10 attorneys who are engaged in representing Mr. Simpson in the defense of this case. But even if we can characterize this as some broader hostility about attorneys in general, we believe there is ample basis to conclude that that hostility arises from the role that Dr. Golden plays as an expert witness and his cross-examination in the course of presenting his opinions.
What is your response to Mr. Kelberg's argument regarding 352 and Fifth Amendment problems?
Well, first of all, we don't believe the Fifth Amendment is a serious problem for the prosecution. They have available to them immunity if Dr. Golden insists that he's not going to testify in this case because his testimony may incriminate him of a criminal offense. There are numerous ways that the people can deal with that, including a statutory grant of immunity.
But that's completely within their discretion, and tactically I'd be astonished if they did that. So that doesn't help us much.
Well, Your Honor, whether there's any realistic interest in the prosecution of Dr. Golden, I think can be gleaned from the records that have already been submitted to you. You have an opinion already rendered by the city attorney's office, incidentally, without even talking to Dr. Golden, indicating that they were not going to pursue prosecution of this case. So whether there is any realistic fear of self-incrimination, or whether that would be simply be used as some sort of tactical tool to avoid cross-examination of this witness, it can be dealt with through the device of immunity. But I don't think we even have to deal with it until there has been an invocation of the privilege, and there's no indication in anything that has been presented to the court that there is any risk of self-incrimination, much less any risk that the witness will refuse to testify on that ground.
But don't we have an ethical issue to broach before we get to that? Then if we have the suspicion that a witness may claim the Fifth, don't we have a problem?
Well, we can call him out of the presence of the jury and ascertain whether he's going to invoke the privilege so it isn't done in the presence of the jury, but I believe that's the only ethical problem we would have. Your Honor also asked, with respect to another aspect of
352 argument.
the 352 argument. 352, of course, has to be approached from the perspective of the relevance of this evidence to show bias. And Your Honor has already addressed that question in the context of Detective Furman's testimony. The extent to which 352 is appropriate where the relevance of the cross-examination goes directly to the bias of the witness. And we believe that whether the bias arises from racial animosity or whether it arises from animosity to any sort of professional group, it doesn't make any difference.
So we want to put lawyers in a protected class like we do race?
Well, in terms of the credibility of the witness, well, yeah, we seem to be plagued with jokes in this case. Frankly, even if this was intended as a joke, a coroner who would make a joke about killing 9 or 10 lawyers 1 year after the tragedy of what happened in San Francisco when a gunman went into the offices of a law firm and shot 8 or 9 people, it's just not a funny joke. And if it's a joke, let the jury hear it and let them decide what bearing that has on whether they should give weight and credibility to the opinions of this expert witness. Now, with respect to the prior mistakes, which are conceded, they, of course, go directly to the question of the qualifications of this witness to give an expert opinion. We have to note that one of the key areas in which Dr. Golden is going to be testifying is his examination of the wounds of the victims and rendering opinions about whether those wounds are consistent with a particular knife, which he was given by Detective Van Adder, whether they are consistent with more than one knife, and whether they are different morphological wounds.
But aren't we talking apples and oranges here, gunshot wounds?
I don't believe we
Let me
are.
tell you my two concerns. My two concerns here are apples and oranges, gunshot wounds versus cutting wounds. And my second concern is the argument brought up by Mr. Kelberg. Let's assume that Dr. Golden in his career has performed approximately 6,000 or 7,000 autopsies. And the prior consistent statements that he raises. Do I then have to, if I allow you to go into that, then do I have to allow the prosecution to then bring in evidence of 6,000 other autopsies that he's done where nothing's been wrong?
Your Honor, very frequently, an expert who is on a witness stand testifying as to an expert opinion is asked, Mr. Expert, have you ever made a mistake? I'm sure you've heard that question posed 100 times. And I'm sure you've heard the same answer all 100 times. The expert says, well, not that I'm aware of. Here we have two conceded mistakes. We have an expert who has admitted that on two prior occasions he rendered an opinion and that opinion was wrong. And how was the wrong opinion corrected? By an addendum to the autopsy report. How many of the 6,500 autopsies performed by Dr. Golden have addendums attached to his report in which he makes corrections in his conclusions? We know one of them does, and that's the autopsy report in this very case, in which numerous addendums have been attached, and we're going to hear, I'm confident, Dr. Golden suggesting that on reconsideration, some of the opinions he previously rendered may not have been correct, that he now has changed his opinion. When the jury weighs what credibility they should give to this doctor's opinions, they are entitled to know that on two prior occasions he was wrong and it was conceded that he was wrong. So we're not fishing around through lots of prior autopsies looking for mistakes. We know going in that there are two conceded mistakes that the jury should know about. And those mistakes are relevant mistakes. They are mistakes that relate directly to the examination of wounds and the nature of wounds. Now, Dr. Golden may have an explanation. He may say, well, I may be incompetent in examining firearm wounds, but I'm not incompetent in examining knife wounds. That's fine. The jury should hear that explanation, and they should weigh it in terms of deciding what credibility and weight they want to give to Dr. Golden's opinion. Our experts will suggest that the same kinds of skills are being employed in the examination of wounds, that people ordinarily aren't experts just in gunshot wounds or knife wounds, that a pathologist should be an expert in the examination of any wound, and his inability to distinguish an exit wound from an entry wound or to identify a contact wound goes directly to the credibility and weight we should give to his opinions about what kind of knife slashing produced a particular wound, what kind of weapon produced it, or whether more than one weapon may have produced the wounds in this particular case. These are areas that we should explore on cross-examination. What we're talking about here is the right to cross-examine. And then we'll get to the question of arguing to the jury, as Mr. Kelberg was doing, about whether they should give greater weight to Dr. Golden or to Dr. Baden or to other experts who may testify in this case. But that function is a function reserved to the jury, and if Your Honor is going to tell that jury in your instructions, give to the expert's opinion whatever weight you think they deserve, then the jury is entitled to hear cross-examination about these highly relevant issues.
Thank you, counsel.
This court will hear a brief response. sufficiently educated on this issue that it's...
Do you feel compelled to respond?
I don't feel compelled to do anything in this court, Your Honor,
All right, thank you, Mr.
other
Gilbert.
than to hopefully be courteous.
All right, thank you, sir. All right, counsel, we've used up, we have one other issue, the issue as to the use of the autopsy photographs. And I did receive from the prosecution a complete set of autopsy photographs that are placed into two groups, photographs that they do not wish to use and those that they do wish to use. However, I must say that the letter that accompanied the photographs did not tell me for what purpose the prosecution wished to use particular photographs. And my guess at this point is that we will not see the autopsy testimony for quite some time, perhaps 3 to 4 weeks, if I'm lucky. Do we agree on that? And Dean Ullman, I understand you have to go back to Stanford.
Well, I was going to argue the sanctions issue, so I may remain over until tomorrow morning to do that.
All right. Do you want to address the sanctions issue? Can you do it in 5 or 10 minutes?
Certainly.
All right.
Your Honor, if you recall, I had asked for time
Yes.
on that. That's why you set it for tomorrow morning, sanctions on the late
That's
disclosure
right.
of the videotape.
Okay, I did do that.
All right. I'll be able to remain until tomorrow morning.
All right, then as
With respect to the autopsy photos, we believe that the court needs to engage in the 352 balance with respect to each individual photo, and that perhaps this could best be done in chambers where both counsel have an opportunity to address the admissibility of each photo and the availability of alternative photos which may not create the same problems.
I might add as well, it would be tremendously helpful to me if I had a one-sentence explanation as to each photograph, why it's relevant or why you seek to introduce it or as to what issue. Because to merely give me a list and expect me to figure out, I mean, I can guess as to a lot of these things, but some of them, the intent may not be clear to me. So it would help me tremendously if I had a one-sentence explanation as to each one of these photographs.
That does not present a problem for us to do, Your Honor. Obviously, we're not going to do that today, and perhaps we can coordinate a schedule with Dean Ullman that's convenient to him, to the court. I think the court's correct that you won't have to see me again, at least, for a fair amount of time, so perhaps we can just put it over. Our primary purpose in bringing the motion was to allow us to know which photographs we were going to be permitted to use so that we can prepare the appropriate exhibits, rather than at the last minute, as the court probably remembers from its days of trying cases, getting the photo mount out at the last second and sticking photos on a board.
Saw it this morning.
I have no doubt of that.
Yes.
But if that's good with the court, that's fine with us.
All right.
So does the court just want to take it off calendar and let
What I would like to, I would like an additional briefing from the prosecution as to each individual photograph they intend on using.
And does the court have a time frame when the court wants to have the hearing held on this?
How about if you submit that to me in 10 days' time?
That's fine.
All right, and then we'll schedule it in accordance with Dean Ullman's schedule. But I have the feeling we'll be mired in this stuff for a while. All right, anything else, counsel?
No, Your Honor.
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
All right, do I need to change court reporters?
Eventually.
Can you go to 3? All right. All right, let's have the jurors, please. of our jury panel. Good afternoon, ladies and gentlemen. All right, Mr. Goldberg, Mr. Fung is on the witness stand undergoing direct examination. Good afternoon again, Mr. Fung.
Good afternoon.
You're reminded you're still under oath, sir. Mr. Goldberg, you may continue.
Mr. Fung, I just wanted to go back for a minute to the discussion of the collection of blood stains and substrate controls. When you collect a stain, if you apply a swatch to that stain and it does not collect the entire stain, what would you do?
I would select another swatch, wet it, apply it to the stain, and put it in the same plastic bag as the first cloth swatch for that item.
And on some of the stains that were collected on in this case, or in fact most of the stains, were there more than one swatch that was used to collect the stain itself? I'm not talking about the substrate control, but the stain.
Yes.
All right. And do all those go into the same plastic baggie together?
Yes.
All right. And then that baggie, or that plastic bag containing the various stain swatches, and the other plastic bag containing the cloth control go where?
Those two bags go into a coin envelope with the photo ID number corresponding to the stain.
Okay, now when you say the photo ID number corresponding to the stain, for example, right before we broke, we were discussing the chart depicting the stains at Rockingham, and there were items that were labeled, for instance, 7 or 8. So are you saying that the coin envelope into which 7 went in would be labeled 7?
Yes.
Stain.
Okay. Well, with respect to the stain that has a photograph, a little card in the photograph that says number 7, what would the coin envelope be numbered?
The coin envelope would also be labeled 7.
Okay, and with respect to a stain that has a little marker next to it that says 8, what would the coin envelope be?
The coin envelope would be 8.
Okay. Now, at approximately 9:30 or so in the morning on the 13th of June, if you need to refer back to your crime scene checklist, you may do so. Did you collect another piece of evidence at the Rockingham location?
Yes.
Was that one that you personally did?
Yes.
Do you recall whether Andrea Mazzola went with you on this particular occasion to collect this piece of evidence?
I recall that she was not present when I collected it.
Okay. Did anyone go with you to show you where this was?
Yes.
Who was that?
Detective Furman.
All right. And what was it that you went to see at approximately this time?
At 9:30, or approximately at 9:30, the glove was collected at that time.
All right. Where was that?
The glove was on the south side of the residence at Rockingham.
Now, when you are collecting items of evidence that contain possible biological material, but other than blood drops, what technique or techniques will you use?
I will use one of two techniques. One is to wear a pair of gloves and pick up the item and place it into a paper bag, or I will use a scoop technique where I will place the bag next to the item to be collected and push it in with a card or pencil.
Your Honor, I have a pair of gloves that is marked as People's 163C for identification. May I approach the witness?
You may.
Showing you what we've marked as 163C. What is that?
Those are a pair of latex gloves.
Okay, and are those the type of gloves that you would use at a crime scene?
Yes.
All right. So you could have used either a glove technique or this card technique that you've described, where you don't touch the item at all.
Yes.
Do you recall specifically which one you used in this instant with regard to the glove that Detective Furman showed you?
I don't recall which one I used.
Okay. But it would have been one or the other according to your ordinary practice?
Yes.
There's no third way that you do it?
Not that I can recall, no.
Okay. So, with respect to this item, do you recall how you packaged it?
The glove was placed in a paper bag, and
And-
the bag was labeled.
Is that what is done with items of clothing like that? A glove, it's put in a paper bag generally,
Depending on the size, yes.
but you don't put it in plastic? A plastic bag as opposed to a paper one?
Generally, no.
All right. Now, when you saw this item prior to you collecting it, whichever technique you used, what did the item appear like?
The item appeared to have some brownish, reddish stains on them. It appeared to me to be somewhat dry with some shiny areas on it.
When you first saw it, before you had a chance to inspect it at all, carefully I mean, when you first glanced at it, how shiny did it appear?
There were just some areas that had a sheen to them.
What to them?
A sheen, a shininess.
Okay. And did you do something further to look at it to determine whether, in your opinion, it was dry or wet at that time?
No, I did not.
What makes you think that it was more likely to be, well, maybe I'm misstating your testimony. Did you testify that, in your opinion, it was more likely to be dry than wet?
Yes.
And why do you think that?
My experience with bloodied clothing and their appearance lent me to that estimation of whether it was wet or dry. It appeared to me to be dry.
Overruled.
Your Honor, at this time, I'd like to mark as People's 165 for identification. Part of the contents of a box that has a number of items in it. I don't know how the court wants me to do that, whether the court wants me to mark the entire thing as 165. I won't be introducing all of them.
All right. How is the box labeled at this point?
Well, the box is labeled with an evidence tag that says booked, date booked 6/13/94, and it appears to contain the DR number, in this case 940817431. It says name book 2, Simpson Nicole, and it has contents 9, 10, 18, 27, and 40 and 53 are crossed out.
All right, which item number in that box are you intending on offering? on
9.
this? 9?
At this time.
All right, sure.
If we can mark the box for identification, and then he can just signify what he's taking out, and we can then use the item. If we could mark the box with a separate number for identification, and then the individual item can be separately marked.
165, the box and contents at this point.
Oh, I'm sorry, it's 164, Your Honor. I
164.
made a mistake on my notes. May I also place a 164 on it, just so there's...
Yes, you may. Thank you.
Sir, I'm showing you a box that's been marked as 164. Can you just take a look at the number that says DR number for us and tell us what that number refers to, or what significance that has in the Los Angeles Police Department?
There is a number in a box labeled DR number that is 940817431. That number is used to identify different cases within the Los Angeles Police Department.
So each case has its own DR number assigned to it?
Yes.
Is that the DR number of our case?
Yes, it is.
All right. And when you packaged up various evidence, would you have used that DR number?
Yes.
Could you now open the box for us and describe what you're doing for the record?
I am using a pocket knife to cut the tape along the top seam of the box. Thank you. I'm opening up the box. Did you want me to remove anything?
If there's an item number 9 in there,
There's a bag within with the item number 9 and the DR number 940817431.
okay, now taking a look at that packaging, is there anything about the packaging that you recognize?
Yes. In black, I see the item number that I wrote on it and my initials.
Okay, the item number being 9.
Yes.
And is that what you assigned to the number, the glove that was found on the south side of the Rockingham location?
Yes, it is.
Okay, is there anything else in that package? I mean, in the box, rather.
In the box, there is a coin envelope with item number 10.
Do you recognize anything on that?
Yes. There is the item number 10 and my initials.
Okay.
And underneath the tape, I can kind of make out the DR number. Also in the box is a bag with the number 18 on it, my initials, and again, the DR number. And the last item in the box is a bag with the number 27, the DR number, and Miss Mazzola's initials.
Do we have any latex gloves at the courthouse? I don't want to use my exhibit over there.
I guess you weren't a Boy Scout.
Excuse me?
Never mind.
Well, I tried to be, but
Mrs. Robertson has latex gloves.
sir, could you open up the envelope that's number 9 for identification and tell us what you're doing?
I am unfolding the bag. Breaking the seal. Reaching in the bag. And within the bag is an envelope. continue?
Yes.
Scissors or a knife?
Scissors. Thank you. I'm cutting along the bottom edge of the bag. And within the bag is a glove.
Now, with respect to the package that you just took that out of, can you hold that up so that we can see it with the evidence tags on it? Okay. Now, does that appear to be a package that was a transmittal package that someone else put it in, or is that something that you put it in?
Sustained, rephrase the question.
Okay. Is that your package or someone else's?
This is somebody else's package.
Okay. So the package that you used is the brown paper bag that has item number 9 and your initials on it?
Yes.
Okay. And does that appear to be the item that you retrieved from the Rockingham location? I'm not talking about
Yes.
the package, I'm talking about the glove.
Yes, it is.
All right. Can you hold that up for us so we can see? Is there a size label in there, Mr. Fung?
There's not one apparent.
Okay, that's all right. You don't have to look any further. Can you repackage that for us now, describing what you're doing for the record?
I am placing the glove back in the white freezer storage envelope and placing the envelope and the glove into the brown paper bag. And placing the bag back into the box.
I'll have the clerk reseal it. Mrs. Robertson, at the conclusion of the day, reseal the envelope, please. Excuse me, the paper bag. Mr. Goldman.
Thank you. Now, in addition to the glove at approximately 9:30 or so, was there any other item of evidence that was collected by either yourself or anyone else in your presence?
Yes,
What was that?
that was a blue plastic bag or container of some sort.
And what item number did you assign that?
That was item number 10.
Did you see the packaging for that being the item that you took out and described as number 10 a little earlier?
Yes.
Okay. For the record, he's holding up what appears to be a coin envelope with red tape and blue tape on
Red,
it.
yellow, and blue.
Kind of festive looking. And how did you first get possession of that item? 10,
Item
back
number
at
10.
Rockingham? Yeah.
That item was on the other side of the fence, and Detective Furman collected it and handed it to me over the fence.
And what was it, the item that he collected?
It was a blue plastic container, some sort of baggie or something. I haven't been able to identify what exactly it was.
Okay, but was it a hard type package or a soft bag-like package? I mean, when I say hard, I mean like Tupperware, or is it more like a baggy type material?
No, it's more of a soft plastic.
Okay. Now, was that the last item of evidence that you collected or was collected in your presence at Rockingham that morning?
Yes.
Okay. May I just have one moment, Your Honor?
Certainly.
Sir, you said that you didn't know exactly what the baggie was, item number 10. Did it look similar to anything that you've ever seen before?
No, but it might have been a gauze wrapper, but I'm not sure.
Okay, could have it been sanitary napkin type wrapper?
Sustained, it's leading.
Could have it been anything other than a gauze type
It could
wrapper?
have been.
All right. Now, approximately what time did you leave the Rockingham location?
We left the Rockingham location at approximately 10 o'clock that morning.
All right. And when you left this location, would you have kept on any latex gloves that you were wearing during the evidence processing and collection?
No.
What would have happened to those?
Sustained, rephrase the question.
Sir, do you have a custom and practice with respect to what you do to latex gloves that you're wearing at a crime scene after you leave the scene?
Yes.
What do you do with them?
I will remove the gloves and place them in a designated trash bag. My instruments or personal items, I will remove the gloves so as not to contaminate myself or other items of evidence.
Okay. Now, when you left Rockingham that morning, did you have any information to the effect that you were going to return?
Yes.
Can you just give us in general terms what you were told?
I was told that a search warrant was being obtained and I may be required to come back to do the inside of the residence.
Okay. So you did not go inside the residence on June the 13th, in the morning?
Not in the morning.
Okay. Where did you go after you left Rockingham that morning?
After Rockingham, I proceeded on to 875 South Bundy.
Now, when you went to 875 South Bundy, where were the items of evidence that you had collected, item number 1 through 10, from Rockingham that morning?
Items 1 through 10 were in bags locked in the back of the crime scene truck.
Okay. Now, before you leave and actually lock those bags away into the crime scene truck, do you do any inventory, or did you do any inventory to see what you had prior to locking them away?
Yes.
What did you do?
Each item that we had written in our notes was accounted for.
So what do you mean by that?
We identified each number individually, item number 1, item number 2, item number 3. We made sure that there weren't 2 number 3s or missing numbers either.
Okay, so you made...
Strike the answer being not responsive, the use of the word we.
Overruled.
Did you do this alone, or did you do it with someone?
I did it with Miss Mazzola.
Okay, and when you say that you're going through to make sure you don't have 2 item number 1s or 2 2s or whatever, does that mean that you're making sure that you have 1 coin envelope that has number 1 on it, 1 coin envelope that has number 2, etc.?
Yes.
Okay, and that you have a total of, at that time, 10 items?
Yes.
Now, you testified earlier that in the 80-some-odd pages of reports that you generated in this case and notes that there were some clerical errors.
Yes.
Is it reasonably possible to make a clerical error of writing down the wrong number on a coin envelope using the procedures that you use?
Objection. Sustained. Rephrase the question.
Okay. Could you make a mistake on the coin envelope by writing the wrong number on it?
Sustained. Rephrase the question.
Could you make a mistake on the coin envelope by writing the wrong number without having caught it during this inventory procedure?
Sustained.
I didn't hear the grounds.
It's leading.
What?
It's leading.
Okay, sir, how careful is this procedure of writing the numbers on the coin envelopes and then inventorying them to make sure that you have the right numbers?
We are very careful when we collect evidence. We collect evidence one at a time, making sure that the envelope that we put the evidence in is the same number as the one next to the card.
To strike as being not responsive, but
Overruled.
Thank you. And how careful are you when you do this inventory at the end prior to leaving the scene?
It's vague. How careful?
Okay, I mean, do you,
I just have him describe the procedure.
excuse me?
Describe the procedure.
Okay, why don't you tell us in detail the procedure?
What
do you,
safeguards are there?
what do you, let me start with this, Mr. Fung. With respect to the items of evidence in their packaging, where are those when you're doing this inventory?
The items are in the back of the truck together.
Okay. Do you put the items in numerical order, or are they in random order when you do this inventory?
request the witness just testify to what he did.
Overruled. Rephrase the question, though.
Okay. What order are the items in when you do this inventory?
The items are in numerical order.
Okay. And then how do you go through them?
I go through them sequentially.
From 1 to 10?
Yes.
Approximately what time did you arrive at the Bundy location?
I arrived at the Bundy location at 10:15 in the morning.
Okay. And what was going on there at the time that you arrived, 10:15 that morning or so?
The area had quite a bit of news media around, and detectives and coroner personnel were present.
Did you see the coroner personnel doing anything at the scene as you arrived?
Yes.
What did they appear to be doing?
They appeared to be processing the body of Miss Simpson.
And when you say processing, where was that taking place?
That was taking place at the east of the front gate.
Do you know whether you saw her in her original condition, or do you know whether she'd already been moved by the time you arrived?
Sustained. Calls for speculation.
Do you know whether, did you see whether the coroner's investigators, did you see whether when the coroner's investigators first got there and started touching the body, or were they already doing it when you arrived?
They were
Overruled.
already doing something when I arrived.
Okay. What were you doing while that was occurring?
I was waiting for a briefing from Detective Lang.
And at some point, did you also see something occurring with the body of Ron Goldman?
Yes.
What did you see in that regard?
I saw at one point, the body of Ron Goldman being processed also. I didn't stick around for the whole thing. Then I was back and forth at the truck.
Okay. And at some later point, did you get a walkthrough of the location from Detective Lang?
Yes.
What happened during the walkthrough?
Detective Lang told me of different items of evidence he wanted me to collect. He showed me some clothing in the cage area. He showed me a trail of what appeared to be bloody footprints and a trail of blood leading towards the west end of the location.
Now, when you looked at these items of blood drops that you described as being the trail, what condition did they appear to be in?
They appeared to be fresh blood stains.
Did they appear stepped in?
No.
Now, did you begin to process the crime scene for collecting the evidence that morning?
Yes.
And did you do that alone, or did you also do that with Andrea Mazzola?
I did that with Miss Mazzola, yes.
In terms of collecting the blood stains, did you do that as a team, as you described at the Rockingham location?
Yes.
Sustain.
How did you do it?
Assume facts not in evidence. Assume facts not in evidence.
How did you do it? How were the items, the blood items collected?
The blood items were collected in the same manner that was described earlier on the board.
Okay. Using the same procedure?
Yes.
And when you were actually doing the evidence collection, I mean, you and Ms. Mazzola, were you wearing anything on your feet?
Yes.
What were you wearing on your feet?
We were wearing protective booties.
Your Honor, at this time, I'd like to show the witness an item of evidence that's been marked as People's 163B for identification.
All right, 163B.
There are actually two, what appear to be two paper-like objects. Sir, showing you those items, what are they?
These are the type of booties that we were wearing that day.
How are they worn?
They are placed over our shoes.
Can you just hold one of them up so the jurors can see it all? What is the purpose of wearing those booties?
I wear them to protect my shoes from biological evidence.
So the booties are to protect the wearer?
That's the main use for them, yes.
Okay. And do the booties serve any function in terms of protecting the crime scene? I'll withdraw the question and ask another question, Your Honor, if I might. Sir, if you were to step in some blood and with the booties on and then step in some evidence, do the booties have some sort of property that would prevent cross-contamination from occurring?
No.
Okay. Are there any disadvantages to wearing booties at a crime scene?
Yes. Booties are somewhat cumbersome in that they're much larger than your regular shoe, and they could track. There's more chance for tracking or stepping in something that you don't want to step in. Also, they're quite slippery and could injure yourself if you're not careful.
So given those disadvantages, why were they worn at the Bundy location?
I wore them because I felt there was quite a bit of blood out at the scene, and I just didn't want to get the blood on my shoes.
Okay. Now, when you were at the location, were you or Ms. Mazzola wearing any lab coats?
No.
Were the fingerprint people wearing lab coats?
Yes, they were.
And you testified that at crime scenes, you would be in charge of the fingerprint people?
In some crime scenes, yes.
Okay. Do you know why the fingerprint people wear lab coats at a crime scene?
The fingerprint people wear lab coats because they deal with fingerprint dust, which gets all over the place, and the dust can ruin your regular clothes. So they'll wear the lab coat to protect their clothing.
Okay. Now, did you use the procedure that you previously described when you were talking about how a stain is collected, of laying out the numbers and doing the measuring?
Yes.
And since you knew that you were going to go back to Rockingham later, what number did you start with at the Bundy location?
I started with photo ID number 100.
Why was that?
Well, as stated before, I knew I would have to return to Rockingham, and I wanted to keep the numbers there in sequential order.
Okay, does that mean that when you went back to Rockingham, you wanted item number 11 to be your first item of evidence?
Upon return, yes.
Okay. So why did you choose starting with 100 instead of 50 or some other number?
I felt that that was a safe number to use because I didn't believe I would have another 90 items of evidence to go through at the Rockingham location that day.
Okay. So the number cards that you laid out started with 100. What was the last one?
The last
At the Bundy location.
The last photo ID card we used was 119.
And those are photo IDs,
Yes.
is what you're saying. Okay. Now, at some later point, did you assign property item numbers to replace those photo ID numbers, or in addition to the photo ID numbers?
Yes.
When did that take place?
That occurred back at the laboratory.
Okay. Did you enter the property identification numbers that you eventually placed on items on the crime scene identification checklist?
Yes.
Okay. So does that list then correlate the property numbers with the photo numbers?
Yes.
Okay. Now, in order to give us specific testimony as to the item numbers, in other words, property numbers of various pieces of evidence that you collected at the location at Bundy, would you have to refer to your crime scene identification checklist?
Yes.
Okay. With respect to the caged off area that you referred to, did you collect an item number 36 from that 35 from that location?
Yes, I did.
And what was that?
That was a set of keys.
Okay. Did you collect an item number 36, or was one collected in your presence?
Compound question.
Sustained, rephrase the question.
Did you see an item number 36 being collected?
Yes.
What was that?
That was a pager.
And what about item number 37? What was that?
37 was a glove.
Do you remember who specifically collected that item?
Criminal Mazzola collected that.
Did you see an item number 38 collected?
Yes.
What was that?
That was a blue knit hat.
And an item number 39?
Yes.
What was that?
Item number 39 was an envelope containing a pair of glasses.
And what about 40?
40 was a ring.
Now, with respect to these items, how did you package those? Were those in coin envelopes or some other type of package?
The keys and the pager were placed in coin envelopes. The glove, the hat, and the envelope with the glasses were placed in paper bags, and the ring was placed in a coin envelope.
And eventually, were those then assigned the DR number in our case that you previously read out?
Yes.
Your Honor, at this time, I'd like to mark as people's next in order. It's 165, a map of the Bundy location.
All right, 165, have you shown that to counsel?
Yes.
This is a chart, Mr. Goldberg?
Yes, Your Honor.
All right. All right, Mr. Fretlow, why don't you keep that closed for just a second? Why don't you close that up for just a second? All right, ladies and gentlemen, I'm going to take a 10-minute recess at this time to change court reporters. Please remember my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations, and do not allow anybody to communicate with you. If you'll just step back into the jury room, and we'll resume in 10 minutes after we change court reporters. Mr. Fung, you can step down. 10 minutes. All right, we're ready to proceed? All right, back on the record in the Simpson matter. All parties are again present. Deputy McNair, let's have the jurors, please. All right, the record should reflect we've been rejoined by all the members of our jury panel. Mr. Dennis Fung is still on the witness stand, undergoing direct examination by Mr. Goldberg. Good afternoon again, Mr. Fung.
Good afternoon.
You're reminded you were still under oath, sir. And Mr. Goldberg, you may continue with your direct examination.
Thank you. Sir, directing your attention to the diagram that's been marked as People's 165 for identification. Do you recognize that?
Yes, I do.
What does that depict?
This depicts the different areas from which I had collected various items of evidence, biological evidence.
Have you had the opportunity to take a look at this diagram prior to today to make sure that it was correct?
Yes.
When this diagram was being made, did you have the opportunity to look at versions of it in order to make sure that they were correct in terms of the measurements and the locations that items were found?
Yes.
Okay. Now, starting with item number 41 on this chart, can you tell us where that is? Where is it? Oh, I'm sorry. What was the first item, sir, that you collected, the first stain that was collected at Bundy?
That would be item 41, which
Okay.
is,
It's not on, it doesn't appear to be on here.
no.
Where was item 41 collected from?
That was collected from a stump in this area here.
For the record, he's referring to the area that has been described as the fenced-off area that's on the north side of the walkway.
Yes.
And for what purpose was item 41 collected?
Item 41 was collected as a reference for the male victim.
Well, when you say now, when you say that it was collected as a reference for the victim, what do you mean by that?
That was where the male victim had been, and that was where he had bled.
Okay. Now, with respect to item number 42, is that depicted on this chart?
Yes, item 42 is depicted here.
Now, that has a little photo card. Maybe we can have that one up there. Item 42. Sir, that has a card in it.
Hold on. Small monitor down below. Chair number 1, can you see that? All right, thank you.
That has a card in it that says 107.
Yes.
Is that correct? Now, what does that 107 represent?
107 is a photo ID card representing the stain at the base of the step right here.
And that was eventually signed item number 42?
Yes.
Now, where specifically was that stain taken from?
Do you want me to show you on the notes, or on the photograph, or
Maybe you can show us on the diagram.
on the diagram? It was collected from right where this dot here is.
Where the call-out line is that leads to 42?
Yes.
Well, how close to the riser of the first step was that stain collected?
Within inches, 1 or 2 inches.
And for what purpose was this stain collected?
That was collected as a reference for the female victim.
So when you say reference for the female victim, is that again something that you believe to represent the female victim's blood?
Yes.
Now, sir, direct your attention to item 44 for identification. Perhaps we can have that photo. Where was that collected from?
That was collected from the north gate, or the north fence area right here.
Okay. And that was originally assigned photo ID number?
109.
Okay. Does the call-out line accurately portray where that was taken from? The
Yes.
fence where that was taken from? Okay. Next, directing your attention to item number 47. If we could have that picture.
.47 was collected along the north walkway, and it was collected right here.
Okay, so again, the call-out line shows where that was collected.
Pretty close, on this diagram, within 6 inches.
Okay. And what about the photo ID number? Was that number 112 as shown in the photograph?
Yes.
And directing your attention now to 48, item 48.
Item 48 was collected here.
Okay, in the area where the call-out line suggests.
Yes.
And by the way, what is the margin of error, would you say, on the call-out lines on this diagram?
They're within inches, maybe a foot at the most of difference.
Okay, so we're talking about fairly general, well, not general locations, but there is some margin of error on this chart.
Yes.
All right. And with respect to item 49 for identification, does this chart depict where that was located?
Yes, it does. 49 was collected from the steps, and that is right here.
Okay. And now directing your attention to item 52 for identification. Excuse me, let's do 50 first for identification. Item number 50. Does this chart show where that was located?
Yes, it does.
Was that located on, where in reference to the back gate is that?
That is east of the back gate.
Okay. And now item number 52 on this chart. Where was,
Item 52 was recovered from the driveway that's depicted here.
and again, as with the rest of the items that I've asked about, the photo ID number is represented in the photo itself.
Yes.
And now with respect to item number 54 for identification, where was that collected from?
Item 54 was collected from the corner of the front gate.
Okay, now there are two photographs on the diagram that's been marked 165 that appear to have a card in them with 119. Do both of those depict what was eventually assigned item number 54?
Yes.
One is a close-up of the other.
Yes.
And 51, where was that collected from?
51 was collected from this south fence right here.
Okay, now which side, if you can look at the photograph that has the 116 card, is that 116 card on the north side of the fence or on the south side of the fence?
That's on the north side of the fence.
Okay. The side closest to where Nicole Brown's body would have been.
Yes.
All right. Now, there's also an item that we don't have a photograph for, item number 57. It says label in the right-hand corner of the chart, just above where it says item number 54.
Yes. There was some type of label collected from the walkway, and that was located right here.
So the call-out line again indicates the general location that was found.
Yes.
What was the purpose again of, why was this label collected?
That label was collected at the request of Detective Blank.
And what did the label say on it?
Referring to my notes. The label said Bonita, Ecuador.
Now, we also have two photographs up here that appear to depict shoe prints. Is that correct?
Yes.
Looking first at item number 55. Maybe we can have 55. Does the call-out indicate on the chart, People's 165, the location that this stain was collected from?
It's fairly close. It was a little more east.
Okay. And now directing your attention to item number 56.
56 was also just a little bit more east of
Okay. East of where the call-out line says it was.
Yes.
So in reviewing these photographs, all the photographs on this Bundy Drive Biological Evidence Board, People's 165, did you compare them against your notes to make sure that the photo ID numbers and the item numbers corresponded?
Yes.
And that the general locations that the call-out lines had them were depicted the general location where it was found?
Yes.
Now, at some later point on July the 3rd of 1994, did you return to the Bundy location for the purposes of collecting some additional stains?
Yes.
And how was it that you got notified to return to the location?
I was requested to respond to 875 South Bundy by telephone. Detective Lang called me.
Approximately what time did you arrive at Bundy on the state?
I arrived there at 11:30.
What did you see when you arrived?
I saw brown colored stains on the rear gate.
And on the rear gate, are you talking about what on this diagram, People's 165, has been labeled the back gate?
Yes, right here.
Approximately what time did you collect those stains?
I collected them at approximately 1:45 in the afternoon.
Okay. Now, directing your attention back to the diagram 165 for identification, item number 50 has a card in it, photo number 115, is that correct?
Yes.
Okay. And item number 115 and 116 also contains a card with a number 115 in it, is that correct?
Yes.
Okay, so there are two 115s.
Yes.
One 115 is from the 13th, and the other from July the 3rd.
Yes.
Now, did you have occasion, Mr. Fung, to take a look at some photographs that were shot on June the 13th prior to testifying here today?
Yes.
Your Honor, at this time I'd like to mark as People's 166 for identification.
All right, 166.
What appears to be a photograph of the rear gate, and I'll place a 166 on the reverse side of that.
All right.
Perhaps we could have, it's, oh, yeah. Apparently counsel wants to approach, Your Honor.
All right, we'll call the order, please. Mr. Fung, why don't you take a seat? All right, Mr. Goldberg, you may continue. People's 166.
Sir, showing you People's 166 for identification.
One, please. Court counsel.
Did you have the opportunity to take a look at this photograph prior to your testimony here?
Yes.
Did you look at it with a magnifying glass?
Yes, I did.
And is this a photograph that was taken on the 16th of June? I mean, the 13th of June, sorry.
13th of June, yes.
Did you have the opportunity to compare that photograph to the photographs which were taken on July the 3rd, at the time that you collected 15, 16, and 115, 116, and 117?
Yes.
Does that appear to be in the same location and the same configuration as the stain that was collected on the 13th?
Yes.
Right.
That's what I heard.
I mean, does the stain in the 13th photograph appear to be in the same configuration and same location as the stain that was collected on July the 3rd?
Yes.
All right. Now, do you specifically recall having seen that stain when you were at the location on the 13th?
No, I do not.
Okay. Do you know whether do you have a specific recall of whether it was pointed out to you?
No, I do not.
You don't recall one way or the other?
No, I do. No.
Had you known of that, had you seen it yourself, would you have collected that?
Yes.
Now, you said that it was your practice to collect representative samples. Why would you have you collected this stain?
This stain was on a different medium than the ground, and it was a location that was relevant to the crime.
Okay. So if you had the opportunity to go back and reprocess the crime scene at Bundy, if you could do the 13th all over again, would have you liked to have collected the stain?
Absolutely.
Now, getting back to the photographs that were taken on July the 3rd, showing 115, can you explain to us why there is a photograph number 115 taken on the 13th and a number 115 in the photographs on July the 3rd?
The photo ID 115, which corresponds to item 50, was done on June 13th, before item numbers could be assigned.
Okay, that was when you were assigning photo numbers 100 through, I think you said 119, is that correct?
Yes.
Okay. Can you continue your explanation as to why the two 115s?
By July the 3rd, 114 items of evidence had been booked into property division, and that was the next item number that was going to be used. And it is preferable to have the item numbers and the photo ID numbers coincide, so when we get to the trial phase, the jury isn't confused.
And the attorneys, too.
Yes.
Okay. Your Honor, perhaps I could make a People's 166A of the item that was shown on the court screen of 166.
All right, 166A, hard copy.
Please.
Now, with respect to the 3 stains that were collected on July the 3rd, did you use the same technique in terms of what happened to the stains to dry and package them that you did with the stains that were collected on the 13th?
Yes.
All right. All right, now getting back to June the 13th and the location of 875 South Bundy. Did any of the blood drops at that location appear to be stepped in?
Along the trail, no.
Okay, and along the trail, you mean which item numbers through which item numbers?
I am referring to item numbers 112, or excuse me, those are photo ID numbers. Item numbers 47, 48, 49, 50, and 52.
When you were out at the scene and looking at these various blood dots as well as the shoe prints, did Detective Lang ask you to do anything in particular in terms of documenting or analyzing those shoe prints and the blood dots?
Yes, he did.
What did he ask you to do?
He asked me to measure and document the different shoe prints.
And how did you measure the shoe prints?
I placed a tape measure down and measured them with reference to items that are immovable within the residence.
Okay, so you documented the measurements of the various footprints.
Yes.
Did you also document the measurements of the various blood dots on what you've described as the trail?
Yes.
Okay. And for what purpose did Detective Lang say he wanted you to look at it, to determine what?
Sustain.
Well, I asked him what he said.
That, what, why don't you rephrase it there?
Okay. When Detective Lang said something to you, said he wanted you to look at these, what did he say he wanted you to look at them for?
He wanted me to do a, I think his term is, the word he uses escapes me right now, I'm sorry.
Did he use a term that wasn't typically used any longer in the that you do not use as a criminalist?
Yes.
Okay. Did it have to do with the strides?
Stride analysis, yes.
Okay. And what, if anything, were you trying to determine by measuring the footprints and the blood dots?
I was asked to determine whether the person was running or walking.
Okay. And what kinds of factors did you look at in order to make that determination?
I looked at the distance between the shoe prints. I looked at the shoe prints themselves to see if there was any splashing effect. And I looked at the blood stains to the left of the shoe prints to determine if there was any trailing or not.
Okay, well, let's break that down for a second. First of all, did you make any preliminary determination as to the shoe size?
Yes.
What was your preliminary determination?
The preliminary determination was that it was a large shoe size consistent with being worn by an adult.
Okay. And you said that one of the things that you looked at was whether or not there were splatters off the shoe prints.
Yes.
Why were you looking at that?
When a person runs, they will have much more force when they hit the ground with their foot, and there will be somewhat of a splashing effect on the surface.
Did you see that kind of splashing effect?
No.
Right. And another thing you said you were looking at was the distance between shoe prints.
Yes.
For what purpose were you looking at that?
When a person runs, they will have a longer distance between each shoe print than when they walk.
And was the distance here for an adult relatively long, consistent with running, or shorter?
It was relatively shorter.
Okay. And finally, you said that you looked at the trailing or tailing on
Yes.
the blood dots. What did you mean by that?
When a drop of blood hits an object, when it has some type of velocity besides going down, it will typically have a splashing effect in the direction that it is traveling. And you can determine direction by analyzing that.
Did you see any evidence of significant tailing on these blood dots?
There was no significant trailing, no, or tailing, no.
And would that be more consistent with someone who was running or moving more slowly?
There would be more tailing with someone who was running.
Okay. Now, respecting the shoe prints and the blood dots, did you notice where in relationship to the shoe prints the blood dots were?
Generally speaking, the drops were to the south of the shoe prints, or to the left if the person was walking in the west direction.
Okay, so if a person were walking towards the west direction, the back gate, the dots were generally to the left.
Yes.
Respecting the board that we've marked as People's 165 for identification, item number 48, perhaps you need to take a step off the witness stand. Can we see this again? Is one of the shoe prints that you observed at the scene on the 13th located in this photograph?
Yes.
Can you tell us where it is by pointing on the diagram? I think you're going to have to point over here.
It is right here.
Okay, but can you tell us where in the photograph the shoe print is?
Up in the upper right-hand corner.
Can you describe it a little bit for us so we can see what we're looking at? Is it a whole shoe print or part of a shoe print? Or?
It appears to be a partial shoe print. Right here, and this is the outline of it.
And the blood dot is also located in this photograph next to the card 113.
Yes.
Now, can you tell us how on the diagram this item would be oriented? In other words, which way is west on the photograph?
On the photograph, going up is west. So to orient this properly, you would have to turn it on its side.
So when you're at the scene and you're looking at this partial shoe print, if the person were headed in a westerly direction towards the back gate, the blood dot is to the left.
Yes.
Now, regarding item number 47, we don't need to take a look at that, but just referring to the diagram, People's 165, was there also a shoe print in the vicinity of that blood dot?
Yes.
And where was that using the diagram?
There was a shoe print up in this area here.
On the diagram, he's pointing to one tile to the north of where the blood dot is, Your Honor, and it's adjacent to the blood dot itself.
Yes.
Well, he's pointing to a row of tiles, again, for the record, that's the row above the blood dot to the north on this diagram.
It's not completely covered, it's to the left of it as we look.
Mr. Fung, why don't you point to it again?
Maybe we can count the number of tiles starting from there. Yeah. Count the number of tiles starting from the beginning.
Appears to be indicating a location that's approximately 1 foot on the diagram, slightly above and slightly to the left. He agrees. Pretty good for not being able to see it, isn't it? I can see right through it.
Okay. Is what the judge just said correct?
Absolutely. Of course.
Okay. Now, when you package the various items that you collected that are represented on this board 165 into the coin envelopes, were the coin envelopes given the, and I'm talking about the ones on the 13th, were they given the photo ID number or the item number?
Objection, comment.
Sustain, what's your rephrase?
Well, with respect to every item that you collected on the 13th, was it given the photo numbers or the item numbers?
With respect to the items that I collect on June 13th at Bundy, the evidence was marked first with photo ID numbers.
Okay, and then later on, you assigned the item numbers.
Yes.
And where was that? Was that at Bundy or back at the lab?
That was done at the laboratory.
And then were those coin envelopes given the DR number that you read off in this case?
Yes.
Okay. Prior to leaving the Bundy location, did you do anything to recheck the items that you had collected?
Prior to leaving Bundy, I conducted an evidence inventory for the items of evidence we collected at Bundy.
Okay. And was that the same procedure that you described earlier when you were talking about doing the inventory at Rockingham?
Yes.
Right? Yeah. Where did you put the items of evidence that you had collected from the Bundy location?
The items of evidence were placed in bags.
No, I mean, but were they taken in and put in the crime scene truck?
Yes.
Was the crime scene truck locked?
Yes.
And when you were processing the Bundy location, where was the Rockingham evidence from the morning?
The Rockingham evidence was also locked in the back of the crime scene truck.
Approximately what time did you leave the Bundy location on the 13th?
I left the Bundy location at approximately 3 o'clock, 3:15.
Where did you go after you left?
I returned to the Rockingham address.
What time did you arrive back at Rockingham?
I arrived back at the Rockingham address at approximately 3:30.
So when you left Rockingham in the morning, your last photo number and item number was 10, is that correct?
Yes.
So would the next item that you collected have been 11?
Yes.
Was 11?
Yes.
Who collected number 11 physically? Was it you or was it Ms. Mazzola?
That was physically collected by Miss Mazzola.
Do you recall who spotted it first?
No, I don't.
Did you see it?
Yes.
Where was it?
That was located on a wire that was hanging down along the south walkway at the Rockingham address.
That was the same side that the glove was collected from?
Yes.
All right, Mr. Goldberg, do you need People's 165 at this point, since we're talking about Rockingham?
No, I don't, but I'm going to need to get to the Rockingham exhibit, and there's an issue that we'd like to discuss with that.
All right. Let me ask the jurors then to step back into the jury room. There's something I need to determine with regards to the next exhibit. All right, Mr. Goldberg, the record should reflect that the jury has withdrawn from the courtroom. Do you want to show me this exhibit?
Yes, well, this is the exhibit that contains the two items that counsel objected to earlier of the sink, I believe, in the shower, where they were objecting on the grounds of showing the phenolphthalein test that was conducted. So that's the issue. We've now arrived at that point, Your Honor.
All right. All right, we discussed this matter briefly this morning, and Mr. Goldberg, you cited to the court the Coleman case. The court has had the opportunity to review the Coleman case, and I have reviewed each of the cases that Coleman cites. Do you wish to be heard?
I don't wish to be heard further, Your Honor. I may respond to what counsel has to say. I mean, I think, as I understand the objections relevance, I think we talked about that objection.
Your Honor, I did have a chance to look at Coleman over the recess. I think there are three significant differences which the court should bear in mind at this time, Your Honor. One is that, first of all, in the Coleman case, the evidence, it was determined that it was error to admit the evidence, although it was deemed harmless error, which had not been pointed out this morning during the discussion. But more importantly, Your Honor, the criminalist who tried to introduce the evidence in Coleman, like Mr. Fung in this case, is not an expert in serology, was not an expert in serology, and that was a factor considered by the court as to why he was not the appropriate witness to introduce that type of evidence. We would submit to the court that, likewise, in the instant situation, Mr. Fung would not be the appropriate witness to introduce the evidence of any presumptive test done on the sinks or drains in the house. Secondly, Your Honor, in the Coleman case, one of the reasons they felt that it was not that it was harmless error, is that the actual items were brought in so the defense could do independent testing. In this instance, those two items were never preserved by law enforcement. And frankly, it's in that sense, there's a Griffin situation here as well, Your Honor, where we are basically precluded from having done any testing at all on those drains. As I pointed out this morning, Your Honor, the appropriate procedure would have been to simply collect some of the liquid in those drains, so any kind of confirmation testing could have been done back at the laboratory. That was not done here. All the other stains for which law enforcement received a positive presumptive test were actually collected. And there's no reason why these samples were treated differently. They certainly could have been brought back and a confirmation could have been done. But frankly, Your Honor, the third concern we have here is again under 352, which is that little pink Q-tip that you see there is not pink because it's showing blood. It's pink because that is the chemical reaction from the phenolphthalein followed by the hydrogen peroxide. That's the nature of the test. And there is this there's a suggestion that he's reaching in with that Q-tip and pulling out blood, which he's not. As I pointed out this morning, Your Honor, there is a wealth of information in the scientific community that shows that this particular situation is fraught with the dangers of a false positive. One article that comes to mind is by Blake and Dillon, entitled Microorganisms and the Presumptive Test for Blood. It's a 1973 publication, and talks about this kind of situation where you do...
Same Blake?
What?
The same Blake?
It's the same Blake who's referred to in the Coleman case in a different context. But one of the things that Blake and Dillon point out in that research in the 1970s is that in damp, moist areas, such as a drain, where you have a lot of microorganisms growing and bacteria, you can easily get a false positive. Coupled with the fact that in pipes, if they're copper pipes, copper also gives a false positive for the pheno test. And I'm not talking about other kinds of vegetable matter, but if you look at the types of things that can give a false positive here, coupled with the fact that they didn't preserve that liquid so it could have a confirmatory testing back at the laboratory, I think when you balance that, Your Honor, that the prejudicial impact does outweigh any reasonable probative value that it has, given that it's a presumptive test. Thank you.
Mr. Goldberg? Certainly.
Reason that this is at all difficult for the prosecution is because there's a tactical as well as a legal issue involved. Counsel, as I'm sure counsel is aware, the defense has also done some presumptive blood testing at the Rockingham location, and they're using the same class of test as we did in the phenolphthalein case, with the phenolphthalein test. So if the court's ruling is that presumptive blood testing doesn't come in, period, regardless of who is offering it, maybe that's a decision that we can live with. But I just think maybe we should clarify whether that's counsel's position, because if it is, then perhaps we don't need to put in this evidence of the phenolphthalein test. What I would say, Your Honor, though, is that we do have some patches for this particular item that we could affix, and I would like the opportunity, if the court is going to rule, if indeed this is the defense position, to be able to fix the exhibit up. It shouldn't take that long. I believe Mr. Fairtlow can do that for us. And if that isn't the defense position, I'll respond to their legal arguments.
Counsel, let me suggest this. Let me suggest that Mr. Fairtlow apply his bandages at this point, allow you to consider the tactical matters over the evening hours. We do have an absolute stop time today of 4:30. I think, and then tomorrow, I have the feeling we're not going to get to that just yet anyway in the next 15 minutes, but we do need to quit at 4:30 today. Sure. And that'll give counsel from both sides the opportunity to discuss their chess match.
Okay, the problem with the patches, as I've just been advised, is that they are unadhesive, the ones that we use, so they can't be removed once applied.
Well, I don't have enough Post-its to... The county only gives me these little ones anyway. Mr. Goldberg, do you have enough that you can just get through the next 15 minutes so we don't lose court time?
Well, that's what I'm starting to look at right now, Your Honor. I might just be able, I hate to take things out of order, but I suppose I could skip over the Rockingham evidence and move on to,
Well, you don't need this exhibit to do Rockingham just yet, do you? And you do have availability of the Laserdisc photos scrupulously, correct? Mr. Fairtlow indicates yes. I'm sure we could do the blood spots in the foyer and the sock collection in the master bedroom before we get to anything else.
it could be done, Your Honor.
Let's do it that way. All right. Let's have the jury. Let the record reflect we've been rejoined by all the members of our jury panel. Mr. Goldberg, you may continue.
Thank you. After the collection of item number 11, did you go inside the house?
Yes, I did.
And what was the first item of evidence that you saw inside the house?
The first item of evidence was a series of red stains in the foyer.
People's Exhibit number 121.
Sir, direct your attention to what's been marked as People's Exhibit 121 for identification. Do you recognize what's depicted there?
Yes, I do.
What is that?
That is the red stains that I previously was speaking about.
Now, when you collected these three stains, were they collected as a single item or as individual items?
Oh,
They were collected as a single item.
And in this case, I take it that the number in the photograph also corresponds to the item number that it was eventually assigned. Is that correct?
Yes.
Approximately what time was item number 12 collected?
That was collected at approximately 4:30.
All right. Now, after collecting item number 12, did you go upstairs in the location?
Yes, I did.
To your recall, what was the next item of evidence that you collected?
The next item was a pair of socks in the master bedroom.
Apparently, that has not yet been marked, Your Honor, so I'd like to mark as People's 167 a picture of the socks.
all right, People's 167.
Sir, directing your attention to what's been marked as People's 167 for identification, do you recognize that photograph?
Yes, I do.
I can't see from here, but is there a tag in this photograph, an evidence tag?
Yes, there is.
What number is that?
That would be that would be number 13.
To your recollection, who physically picked these socks up, yourself or Andrea Mazzola?
That was me. I picked them up.
And you described two techniques that you used to collect this kind of evidence. Do you recall which one you used here?
No.
So it was either the scoop technique or the glove hand technique.
Yes.
What kind of packaging did you put these in?
Those were placed in a paper bag.
And that was assigned item number 13? The paper
Yes.
bag?
Yes.
And given the DR number in this case?
Yes.
And and did you then collect another stain from the upstairs area after collecting the socks?
Yes.
Where was that from?
That was collected on the floor in the master bathroom.
That's going to be People's 168 for identification, Your Honor.
Right, 68.
What does 168 portray?
168 portrays Criminalist Mazzola performing the phenolphthalein test on item number 14.
And can you tell us where in that photograph the stain is located?
The resolution on the monitor isn't that good, but the stain is close to where she is pointing with the applicator.
Did she physically collect that stain or did you?
She physically collected it.
Was that in your presence?
Yes.
And did she use the same procedure that you previously described in terms of collecting stains?
Yes.
And that was assigned item number 14?
Yes, it was.
And do you have an approximate time frame for when 14 would have been collected?
That was collected at approximately 4:40 in the afternoon.
Now, according to your crime scene identification checklist, did you pick up another piece of evidence around 5 o'clock?
Yes.
What was that?
That was an airline luggage ticket, and that was located on an airline ticket receipt, and that was located in the garbage can south of the foyer.
And that was picked up at what time?
That was picked up at around 5 o'clock.
And what item number was that assigned?
That was assigned number 15.
And what was the last piece of evidence that you came into possession of while you were at the Rockingham location in the afternoon?
That I collected directly, or?
That you came into possession of?
That was a airline luggage ticket on the bench outside the front door.
Okay, but did someone give you something later after the...
Sustain, phrase the question.
Did you get anything from anyone else?
Yes.
What time?
That was at 5:20 in the afternoon.
And is that an approximate time again?
Well, I looked at my watch for this one, and I remember doing that, so it's fairly accurate.
So the other times that you've testified to at Rockingham in the afternoon are approximate except for this one?
Yes, because I definitely remember looking at my watch for this one.
What was given to you at approximately at 5:20 in the afternoon?
A envelope containing a vial of blood labeled O.J. Simpson.
Who gave it to you?
That was given to me by Detective Van Adder.
And do you recall whether it was a vial itself that you received, or was it already in some sort of packaging?
It was in a gray envelope.
Okay. I'd like to mark an exhibit that we've previously identified. It's People's Exhibit 163, and this would be H. It's a white, gray, and yellow analyzed evidence envelope. They're all stapled together. Can I mark them collectively as H?
So Mark,
The council has seen them. May I approach the witness?
you may.
So showing you these analyzed evidence envelopes. Have you seen that kind of envelope before?
Yes, I have.
And what are those three types of envelopes?
The white one is the envelope we use for storing frozen evidence. The gray one is used to store refrigerated evidence. And the yellow one is used to store things at room temperature.
Okay, so the item that you received was in the gray envelope.
Yes.
Do you know where Andrea Mazzola was at the time that you received that item from Detective Van Adder?
No, I don't.
What did you do after you received that item from Detective Van Adder?
I labeled I wrote down on the package that I had received it from him, and then I proceeded to the crime lab.
Did you use the same inventory procedure for the items that you had collected in the afternoon at Rockingham before you left?
Yes.
Now, at the time that you received the evidence from Detective Van Adder, the blood vial, where was the evidence that you collected from Rockingham in the morning?
The evidence that I collected from Rockingham in the morning was in the crime scene truck. It was locked in the crime scene truck.
Okay, so that is your procedure when you have evidence in your truck and you're still working at a crime scene, that the truck's locked?
Yes.
And where was the evidence at that time that you had collected at Bundy?
The Bundy evidence was also locked in the rear of the crime scene truck.
And at that time, when you received this file from Detective Van Adder, where was the evidence that you had just collected in the afternoon at Rockingham?
That evidence was next to the crime scene kit.
What is the crime scene kit?
The crime scene kit is the baggage or luggage that we use to carry about all our instruments and bags and chemicals to process crime scenes.
So were you maintaining physical possession of the items that had been collected at Rockingham in the afternoon in your crime scene kit as you collected them?
I believe they were placed in bags carried along with the crime scene kit.
Okay, but they were in your physical possession.
Yes.
So at the time that you received the blood vial from Detective Van Adder, all the evidence had either been collected and placed in the truck or was in your physical possession?
Yeah.
Sustain. Phrase the question.
Okay, were all the items that you collected either in the crime scene truck or in your physical possession at the time that you received the vial?
Yes.
Compound. It's leading. Where was the evidence after you collected and
That's
as you
okay,
collected?
I think it's already clear, so I'll withdraw
All right.
the question, Your Honor. Now, after this evidence had been given to you by Detective Van Adder, what did you do with it and the rest of the items?
Could you repeat the question?
After you got the vial from Detective Van Adder, what did you do with the vial and all the other items that you collected in the afternoon at Rockingham?
I placed the items from Rockingham and the vial in the crime scene truck,
Where did you go?
and I went back to the crime lab.
Was Ms. Mazzola still with you at this time?
Yes, she was.
Okay. And approximately what time would you say you arrived back at the crime lab?
I arrived back at the crime lab at around 6:30 in the evening.
What did you do with the various pieces of evidence that you had collected from Rockingham and Bundy after you arrived back at the crime lab?
I transferred the items of evidence into the evidence processing room.
And is the evidence processing room there at Piper Tech?
Yes, it is.
What did you do with it once you got into the evidence processing room?
The biological evidence was further processed so that it could be dried, and another inventory of all the evidence was taken.
All right, would this be a good spot?
Yes, it would, Your Honor.
All right. Mr. Shapiro, Mr. Cochran, Ms. Clark, is there something we can agree upon at this moment?
Yes.
All right.
UCLA.
Yes. All right. All right.
They will trounce Arkansas.
All right, ladies and gentlemen, we're going to stand in recess at this time. Please remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case, don't conduct any deliberations, don't allow anybody to communicate with you with regard to the case. We will stand in recess until 9 o'clock tomorrow morning. All right? Thank you, counsel.
Can we approach Your Honor on one thing?
Sure.